Happy Thursday, law nerds. Welcome. Sorry that I was running late. I was chitty-chattering backstage a little bit, and that is totally my fault because I do that. Tonight, we are joined by a special guest, Natalie Lawyer Chick, and Nate the lawyer is going to be joining us when his internet decides to play nicely with him. But I am so excited to have this creator on. She breaks down the law with no BS. She goes through court hearings and gives you like commentary play-by-play on what the attorneys are doing, how they're doing it. She's a criminal defense attorney and a YouTube badass. I'm so excited to have her here. I'm just going to bring her up because we are so law nerds. I know you love Natalie Lawyer Chick. Those of you that haven't met her, welcome Natalie Lawyer Chick. I'm so excited. Do you want to let everyone know kind of a rundown of who you are and what your YouTube channel is about, how long you've been practicing law, what you practice? That would be great.
Sure. All right. So my name is Natalie. I am a criminal defense attorney practicing in the state of Maryland. I'm originally from New York, and I have been practicing for 10 years. I haven't been doing criminal defense that entire time. I took a little brief hiatus to do workers' compensation. So I did criminal defense for like 5 years. I did workers' compensation for like 2 years. And then I went back to criminal defense because I was like, what am I doing? I don't like this at all, you know? And it's been my passion. I'm originally from Queens, New York. My family is all from Jamaica. I'm like the first person in my family born here. So, you know, I'm the child of immigrants. And awesome. I started YouTube in 2007 or 2008, something like that. Like with the year that YouTube first started is when I started YouTube, but I only did like hair tutorials and stuff like that because I was like in college and law school.
Yeah.
And then I decided mid last year that I was going to start switching to law-based content just because, you know, I just felt like it would be interesting to do. And it just took off from there.
Because your content's incredible. And you really do give like sports commentary play-by-play of what the lawyers are doing in court and really let people see kind of the good, the bad, the sassy, the ridiculous, and bring your own experience to it, which I love because we don't get a ton of defense attorney perspectives. A lot of legal commentary is from people who are on in the civil side and have not done criminal trial work. And I am seeing that Nate is here too. So I'm going to bring him up and welcome him to the channel. You guys have some New York connections. The channel is familiar with Nate the lawyer, former police officer, former prosecutor, YouTube commentator, all around general amazing guy. And he's got a video on his channel about women's soccer that has hit over 600,000 views. Nate.
What's going on? How's everybody doing?
How are you? Have you met Natalie? You just briefly missed her introduction. Have you met Natalie yet?
No, I haven't. This is my first time meeting her. I've seen some of her stuff. I'm actually subscribed to her channel. But hey, Natalie, you're from New York too, right?
Yeah, nice to meet you. What part of New York are you from?
Well, I'm from Harlem, but I live in Bronx. You know.
Yeah, yeah. My brother lives in Harlem now, so yeah, I'm really familiar.
All right.
I love it. So we're going to get into a chat a little bit about our kind of YouTube wandering journeys to become like YouTube lawyers, though. We're not YouTube lawyers because we're not employed by Google. I bet Google pays well, though, if we were YouTube lawyers. But it would be way more boring than doing commentary. So I'm going to hit the intro to remind you all that this is not legal advice. This is talking it out with lawyers. This is like getting to sit at the bar with lawyers after work is what this should feel like. And telling some stories, having some chats, and we're going to get into it. So let's get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. I love it. Welcome back, everybody. So, Natalie, you are a defense attorney. Have you worked in the public defender's office, or are you a bar panel attorney working privately?
I work in the public defender's office. I'm a public defender.
Awesome.
Yeah.
Very
Proud
nice.
public defender. I love it.
I had a lot of, it's funny because I had a really good relationship with a lot of the public defenders I worked with as a district attorney. Oftentimes, there were times, not always, we didn't always see eye to eye, but oftentimes we were all trying to figure out how to do the best thing for the case. And that varies, of course. Mileage may vary who your prosecutor is, who your defense attorney is, and how personalities go. But it's so interesting because the amount of kind of hate and flack I got as a DA, the public defenders got it just as much from their clients. It's spicy how much vitriol y'all get sometimes. And it always surprised me because I was like, they literally have dedicated their career to fighting for your rights, whether you like it or not. What is happening? So it always surprised me. Did that surprise you when you became a public defender?
No, it didn't surprise me. I mean, growing up in the community that I grew up in, I wasn't a stranger to public defenders or legal aid or anything like that, or Queens defenders, Bronx defenders. I was, familiar with them. And I actually did an internship with legal aid in college. So I worked with legal aid in New York. It's like our equivalent of public defender. Mm-hmm. I worked with legal aid from college all the way through law school. And so, I remember my first ever experience of going into a jail. I was going with the attorney I was working with to go into Rikers Island, and she was going to go, interview her client. And I was like 17 years old. They were like cursing us out. And I was just like, and I think pretty early on, I got used to the idea that it's a matter of proximity. You're the closest person to them, and they're frustrated, and they need somebody to vent frustrations to. That's not always the case. I have some excellent client relationships, but we get our fair share. I think we get our fair share.
And you don't really, as a public defender, you don't really get to pick. You get assigned cases, however your office assigns cases, and that's what you're working with. And that's the same as a DA. You don't get to pick. And there were plenty of cases where I was looking at victims. I'm like, I am fighting for you. And they're like, fuck you. I do not want to be here. And you're like, oh, interesting. Okay, here we are. Because you're inserting yourself into what other people have going on in their lives, essentially. And it is definitely upsetting. Now, Nate, you went police department, then to the DA's office. Did either of you know that criminal law is what you wanted to do when you were looking towards law school?
Well, since I was a peace officer for about 11 years, and my boss, who happened to be it was the captain of the department. He had just asked me, he was like, yo, what do you want to do with your life? And I was like, I like doing this. And he was just like, well, is this, is this really what you want to do? And I said, you know what? I'm a big fan of Law and Order. I really do. I like the Jack McCoy type scenarios. And he was like, well, if you do want to be a lawyer or not. And I'm like, you know what? I do want to be a lawyer. I would love to be a lawyer. Right. And he was just like, well, do that. Why don't you just take the LSAT? Why don't you do it? And my job actually paid for all of my education. So my undergraduate was paid so I had a free ride all the way through, and they would actually pay for my legal education. So they were like, yo, if this is just something that, why not take advantage of? Not many people can do it. And we're going to be cutting some of the bill, do it. So I was like, all right, I'll do it. And since I had all the connections in both law enforcement and at the DA's office, because I had run some cases, it was just like, oh, great. I knew first day in I was going to be an ADA. I was like, it just was like, that's what I was going to do. Everybody knew it. And, it's funny because in law school, you have the defense attorneys who don't really like the DAs, and they seem to be the evil people. You're working for the man. But like day one, I was like, yo, that's what I'm going to do. So if anybody had a problem with it, it just is what it is, because that's just what I was going to do. So I knew pretty early on I was going to be a DA coming out of law school. Yeah.
Same. I mean, I went to law school knowing that I wanted to go into criminal prosecution after having some too many conversations in college about women who had very aggressive SA situations, and just going, you know what, I think I can do this with more dignity, and I think I can do this better, and I want to do that. But I always I also played college water polo, and I was the one on the team. Like, if you pick on my girl, I'm off the bench and in somebody's face. And that I maybe not the best reason to become a prosecutor, but I'm like, I've got this. I can do this. I can help. And really loved being a part of it. I also liked, I'm a little bit of a control freak. I liked the ability to say, this is BS. We're not doing this. This is not what's happening with this case. Or yes, I really believe in this. Or yes, I really trust what this defense attorney is telling me. How can we resolve this? Because I mean, Natalie, I'm going to let you speak on this, but you as a defense attorney, you get stuck with what you get stuck with. And you have to work with the DAs, where DAs can actually go to their bosses and fight for cases to get rid of them, or to go harder for them if they want. Did you know that criminal was where you wanted to go?
Yeah, I knew it. I knew criminal was what I wanted to do. I always tell people I had an experience with a family member having charged in the criminal justice system. So I said, yeah, this is what I definitely want to do. And it's kind of funny what you just said about, playing water polo. For me, when I was in like middle school, everybody used to say, "Oh, you're not their defense attorney. You're not their attorney, Natalie."
She's like, "I've got this case."
Yeah, I was like, people would get in trouble. Like this one girl got in trouble for talking in school, and we both got sent to the principal's office because I was like, "She was not talking. That wasn't her, guys. That wasn't her." And the teacher sent us both to the office, and the principal made us like, "Okay, you guys just like stay here. The teacher's really mad at you, Natalie." So you need to like
the office.
But you're like, no, right is right.
Yeah,
and I want to lend my voice to right is right.
Yeah, I just always had like a really strong sense of like, this is not right, and I am going to help this person, right? And also a control freak, type A type of personality, and it just was meant to be. That's what I was meant to do.
I love it. And you are still, so Nate and I are more full-time content creators. You are still in court on the regular.
Oh yeah.
How has that been with COVID?
That's been crazy. So first of all, everything's been virtual for the most part. And then randomly they're like, this is going to be in person. I'm just like, why? Like, what is this? What's going to be in person? It'll be like, we're gonna have, no. It's just like, okay. So it's like, they're supposed to have a system in place where if the person's in jail and it can be done in district court, you don't need to bring a jury in. You're supposed to have a trial. That's fine. I'm all for that, but it hasn't been actually working out that way. It's like we've been showing up in person and the prosecutor's been in all process dismissing the case. And it's just like super weird, or asking for continuances. And I'm like, why did we come here? Why did we expose ourselves for this? Right. But for the most part, we have learned that many of the things that we required people to leave work for and get babysitters for, and, have to get someone to cover them for, we could have been doing that virtually all the time, like status conferences where we're just like, when is this case going to go to trial? What's the motions issues in my like felony cases? Oh, that could have been done virtually this entire time. I think that they're seeing that. And so there's like a good thing that's going to come out of that. But yeah, so things are pretty much like stalled. Like I've got people that have pretty serious cases like murders and carjackings and things like that. And they have been sitting since 2019, since the end of 2019. And with no trial date. And we're going now with trial dates getting set in 2022. So we're supposed to be easing back into jury trials, but we just had our first, we've had our first jury trial since the March when everything got shut down in 2020. And it took, for jury selection, took 4 days. That is not normal. Jury selection usually on like just any old regular felony, it'll usually take a day at most, or maybe like 4 or 5 hours tops. But here it's taken 4 days because of like the social distancing and stuff like that. So
they've just waived the 30/30s.
What's the 30/30s for you guys who have that term?
Speedy trial. Speedy trial.
Oh, yeah. So basically in my state, habeas corpus has been suspended per ruling of the chief judge, our equivalent of the Supreme Court, which is the Court of Appeals of the state of Maryland. So habeas corpus is suspended. And what we have is called a Hicks date, Hicks v. Maryland, which is 180 days from the date of arraignment is when your trial is supposed to take place unless good cause is shown. And all the judges have found good cause to go past the 180 days due to the pandemic.
COVID.
And then on top of that, because of the judge's order, all of the HIC states have gotten pushed out like a year. And then on top of that, they were getting continued past that additional year of being pushed back. So no, I mean, at the end of the day, when people start to really get slammed with real trials and actual convictions, there's going to be some serious, like, speedy trial consequences. Like, some serious cases are going to come back on appeal just because.
Yep.
Yeah,
no, because there's some consequences. So I wanted to get into YouTube journey more, but we're getting into defendants' rights, and I would love to talk about that a little bit because it's something I talk about from a prosecutor's perspective. And there's people sometimes who are like, "Wait, you care?" I'm like, "Yes, we all should care. Everyone should care. Everyone should care about protecting constitutional rights. It doesn't matter what side you are." And from a prosecutor's perspective, I don't want anything to come back on appeal that we've put witnesses through, defendants through, courts through, juries through, victims through. You've put people through a trial. I don't want that to come back on appeal because rights weren't upheld, things weren't done right. I think it's often not hard to do those things right. Stuff does happen, but I want to protect, if there is a conviction, protect that conviction for all those involved. And if there shouldn't be a conviction, protect that too. So it's interesting talking about the suspension of rights. That's been happening in California too, because the courts keep finding good cause. And I've been on a couple hearings recently with regards to some of the pop culture cases, and they read out the whole, like, this court has found good cause to do this not in person because you have a right to arraignment in person. You have a right to a speedy trial. And some of these rights are just getting kind of rolled over because it's like, well, the public interest is in protecting the public from the pandemic. I'm like, but also there's people sitting in jail. So, and that's where we see some states like California changing who is going to jail, what they're doing with bail. So people aren't just sitting waiting for trial dates. Has Maryland done that as well?
They're supposed to be, but the actual effect. Okay, so
she's like, nope.
They're supposed to be, but in practice, they're not. And you have to take kind of like what I'm saying with the context of most of my cases are serious felonies. That's what the majority of them are, right? So they're charged with some really, really serious crimes, with really serious injury or property damage, usually serious injury. And so under most circumstances, the court would find this person to be a danger to the community based on the charges in and of themselves, right? That's like the default. But so that's the bulk of my cases. So a lot of my clients are held pretrial, even though they have diseases that make them more vulnerable to negative outcomes from COVID, which is one of the factors that the judges are supposed to consider to release a person. I have not really found that to work in my client's favor. Maybe 3 or 4 of them, it's helped them, but for the most part, no. Now, my colleagues who take mostly district court cases, they may have a bit of a different experience. Are you really going to hold this guy who has a serial trespassing issue? He can't stop trespassing at the 7-Eleven because he's indigent and this is where he goes to get some warmth and, use the bathroom and stuff like that. And they're just tired of him. Maybe you let that guy out, but for the most part, it's not really changing that much. And we have this thing called pretrial services, which are supposed to be in place to monitor people who have more serious charges with, home detention, which is basically a GPS tracking device. They're so overwhelmed. They're not taking people, not because the person wouldn't otherwise be qualified, but just because they're unable to do it. Because remember, there's a backlog of cases. Crimes are still happening. People are still getting charged, right? Like you can't not charge people, right? Crimes are still happening. People are still getting charged. And then there's a backlog. The jail is supposed to only keep a certain amount of people in there. I'm not sure how they're able to reduce those numbers because it's really hard to get people out right now. Because
you can't monitor them when they're out, and then people don't want to deal with the liability of what happens if something happens when they're out. And COVID has really shifted what's going on in the criminal justice system, particularly because with civil stuff, and I talk about pop culture stuff, and Jen Shaw's facing, money laundering charges. She's a Real Housewife. She's out on a ton of money. It's a nonviolent offense. But for, state level courts with violent offenses, it's really it's really something to be considered, because at the end of the day, some of these offenses, you shouldn't be in custody for 3 years waiting for a trial when you're not going to get 3 years if you go to trial and get convicted. It just doesn't make a whole lot of sense at the end of the day.
I know in the Bronx, we had the backpack case. We had the kid who was arrested for stealing a backpack, and he was in Rikers for something like almost a year. Matter of fact, he had been waiting for trial longer than if he was convicted on the backpack charge. He would have been out in like 6 months, but he had been waiting like a year and a half and committed suicide with it. And that led to our bail reform. So my issue here is that just imagine a caseload for both the defense attorneys and the because like you're saying, if you can't get those cases off, if you can't, go to trial or plead out these cases, and they're just piling up I remember we used to hold something like 70, 80 cases sometimes. I remember the max was like 120 at one point. So I can just imagine that must be blown.
That's insanity. 120 cases on a caseload. Was that like a misdemeanor caseload? Because I can't imagine that on a felony caseload.
Wait, for attorney?
Yeah, when my max caseload, well, my partner had
not okay.
My max was something like 75, but they were all misdemeanors. So I had 75, and I had like 4 investigations. I had one from Nigeria, a baby, something or other. And so my felony investigations, I had 3 of those, but then I had like 75 misdemeanor cases that we had to run. But that was average though. You had between 50 and 75 misdemeanor cases that you had, and they were always coming in.
Yeah. So when I was practicing it's funny how things have changed. When I was practicing on the Eastern Shore of Maryland, that's when I was doing mostly district court, which would be our misdemeanor cases. So I couldn't even tell you how many active cases I had at that time, because I would go into court to cover like one docket, and there would be like, here's your 40 people for today.
Same.
Oh
my God.
Same. And for me, it was like, here's your cases for today. Good luck reading them. Some of them might be set for trial in the next 2 days. And then here's your pro per caseload for today. So it was a very interesting running misdemeanor court from a DA perspective, with pro pers, who are people representing themselves in misdemeanor court. Then you have the public defenders who you work with day in and day out. And then you have private attorneys that just walk up behind you and like tap you on the shoulder like they know you and are like, hey, can I just get my case heard right now? And the public defender would be like, bitch, I've been here all day.
All day. Get in line.
We're running our cases first. Yeah. And then the private attorneys would come in and be like, but I've got to be in these 3 other courts. And it's like, what do you want from me? We're in the middle of our list. Like the public defender and I were like, we have a list. We're not done talking yet.
Yeah. Oh God, that brings back so many memories. Yeah, my husband's a private attorney, so I get so jealous because he still takes misdemeanor cases and stuff like that. Obviously, that's like the lifeblood of private practice. And he'll go in and like come back from court, and I'm like, you're done already? When I used to do district court, I would be in there all day, 8 a.m. to like 6 p.m. in the courtroom. Forget the time you had to be in your office beforehand and the time you have to be in your office afterwards. I mean, we used to, oh God bless him. But we had this one judge who was so verbose. He would give you a great bench trial now, and you get a not guilty out of him, but you would be in there till like 7 o'clock at night. Like he went on and on. Like
that's so funny, because in Los Angeles County, with the court reporters union rules, court ended at 4:30, and if it had to go to 5, because you had to deal with the bailiff scheduling, the busing back to county, and the court reporters. So you needed permission to go beyond 4:30 to 5. And then it was a hard stop at 5. There was no going over 5 p.m. because it screwed up the entire county busing schedule. And it was very strict, but God loved the sheriffs and the court reporters union, because it was mandated that we got a break for lunch, and it was mandated that our days had to stop. Now, my days didn't stop when they stopped, because you've got to write up all your stuff, but at least court wasn't still rolling. So you had time to catch up on paperwork in your office at the end of the day. So
I'm so jealous.
It blew me away watching some of the courts that we've seen now because of COVID, live streaming on YouTube. Watching how different courts operate in different jurisdictions has been really interesting. And Natalie, you watch a lot of courts. Do you have a favorite that you're watching streaming on YouTube?
Yes. So So, Judge Middleton. Judge Middleton in St. Joe's County in Michigan.
I mean, did you know when the pandemic started, had you been commenting on videos of court before that or no?
Not of like live court or court that had just happened. So, listen, pre-pandemic, I was doing like a lot of sovereign citizen reactions, right? Like when
we got to talk about that too.
The reaction space. I was doing a lot of sovereign citizen reactions because, and honestly, it was my husband's idea. He was like, you should react to these, you know, because they're awesome. They're so funny. And I was doing a lot of those. And then, you know, court started going virtual and I was like, this is awesome. This is like, I would like leave my own virtual court and then plug into what Judge Middleton's doing over in Michigan or Judge Archer in Michigan as well. She's in Detroit. Oh, yeah. She's amazing. She's got such an awesome manner to her. And I would just be so into it. And then it just kind of like snowballed from there.
I love it because I really stick mostly to documents, but I love how accessible you make the ins and outs of court procedure and how attorneys work. The case with the attorney who called in, the defense attorney who got held in contempt, that you broke down, I was sitting here like this the entire time. I'm just like, no, you didn't. No, you did not. Oh my God, no, you didn't. So I love that you react that way because you get to see it because it's different watching it and hearing it live versus reading it in documents. I still sit here and go, oh my God, no, you didn't. You didn't just say that. Oh my God, you didn't file this. But Nate, have you done any reacts to the live court proceedings?
Not really. I'm like you. I'm more of a document person because this new, you know, seeing behind the curtain in the court is something new for us, right? Because before the pandemic, you know, it was like you really couldn't see it unless you actually went, but now you can actually see it. So, but no, I'm actually thinking about doing more of that because let me step back because I don't want people to say I'm lying. The Derek Chauvin case, because that was live, so I was reacting to that for like 5 days because it was like at the end. So that's like the only one that I've actually, and it's interesting because there was just the audience it's court seems so familiar to people who don't really work, but then when they actually get to see the process, it's so foreign. They're like, wow, we don't know any of this stuff. And I'm like, yeah, why do you think we go to law school to learn this stuff?
This shit goes way slower than it does on TV.
Oh yeah.
Hour, right? The case is closed in an hour. I'm like, yeah, this takes a little longer than that. It takes a little longer.
And there's a lot, I think people don't realize how much lawyering goes on in the middle of things. It's not just like you're having a witness, then you might be having an evidentiary hearing, then you might be having issues, then the jury might have to be out and then back in. And this is really the first time people are getting to see those conversations that are happening sometimes with the lawyers. And you're getting to see, could we talk about Judge Middleton's lovely court bombing with somebody named Buttfucker 3000? Have you reacted to this yet on your channel, Natalie?
I haven't. It's too short. I'm thinking I'm gonna like react to. I mean, like,
or do a reel or do a short. Do a YouTube short for it.
I should do a YouTube short for it. It's I mean, like 15 seconds. That's all I need. And the fact that Judge Middleton like said it. He said it. You know?
He said it. He was like, "Your name is not Buttfucker 3000," and the guy's like. Was he a participant in the court proceedings?
He was a part of me. I genuinely believe that he must have changed it when he was Zooming with some friends, or maybe one of his kids did it or something. And he wasn't maliciously, this is the defense attorney rule. He wasn't maliciously going into court like, I'm going to be Butt 3000. That's me. You know, like the way he looked, he was like, actually,
no, he looked shocked.
Happened. I don't know. I'm gonna get you out of here so you can figure yourself out.
But he brought him in to say something because they're in Zoom waiting rooms. So he brought him in to have a conversation with him about it. And I kind of love that he just did it because it gives us this great moment. But he looked, even to me, he looked mortified to me. He really did look shocked. Did you watch it, Nate?
No, I haven't seen it, but the way you guys are describing it, it sounds like amazing. I'm going to be soon as my internet comes back up, I'm going to be right on YouTube begging.
Oh, his Zoom name. We have 2 super chats, so I'm going to pull those up real quick. And audience, I know you're here. We're gonna absolutely have some chat with the audience. I promise. A question for all the lawyers on this panel: what changes would you like to see happen? Would they be possible during COVID? I mean, changes to the criminal court. There's lots of things that can change in the system. I mean. Do we have one big change that's been on your mind or heart? I think we could do it that way.
Paperwork. It's like the one huge thing I used to hate is the files. It's like all this could be electronic. Like there was so much useless paper that you just had for no reason. And I think the one good thing about COVID, it's forced them to stop being so antiquated in their thinking. So now you see more technology, you see more, databases, even though there's a security issue with it, but it's just getting out of the Stone Age. Like at one point we're like chiseling, things in the stone. I'm like, what the hell? We have computers now. Let's move this thing forward. But, it's such a big bureaucracy. It's hard to just bring them into the future, but it's a simple thing. Like, having iPads instead of these, mountains worth of folders, and you just, it makes it just so simple. So hopefully that would be one change. I think that would make the whole process so much simpler. And the number 2 is the information between the police and the DA's office. I don't want to see another police report that's written and somebody handing me a piece of paper. Why are you giving me paper? Again, this should just be all electronic. I should just get it. It should be all.
And you can just you could literally just bait stamp everything automatically and send it to the defense, and then you're never worried about a page missing, a this missing, a that missing. That makes a lot of sense to just have it digital. It goes to the DAs, redacted if needed, goes to the defense attorneys. No big deal. Like it shouldn't be hard. And the thing that's different, you guys, from civil and criminal is in criminal, you give them everything, all of the things. You just give them the things. This isn't strange. It isn't weird. Sometimes stuff is redacted to protect people, but if the defense attorneys need it, they let you know. Most DAs aren't dicks about it. But it shouldn't be hard to just be like, here's everything we have, now you have it too. But stuff gets lost in the shuffle with paperwork. I had a case that I got on my desk for a preliminary hearing for a homicide, and we didn't have a murder book because he had been out of the country and had come back into the country, so the case was old. And the defense attorney's like, do you have a murder book? I'm like, sure don't. She's like, do we have an autopsy? Like, do we know somebody's dead? I'm like, working on it. Sure would love to have that for you. It's just wild when you don't have that easy flow of information, especially on older cases. But Natalie, what would your change be? And I'll tell you my
more transparency in police misconduct records. So that's a major issue for us here. It's actually something I'm advocating for, and it's a statewide issue, so it's not just local to where I am, and it's also a national issue. So I'm working with a national database on police misconduct. I think that should be, we just changed the law here that police personnel files are usually confidential, but the legislature has determined that police misconduct is not a part of their personnel file. It's not HR if you're like beating people up and, illegally entering people's homes or planting evidence on them. Like that type of stuff is not a part of like, oh, you didn't work as many hours as you put on your card or whatever. It's
Right.
not the same thing. So I want to see more transparency in police misconduct records. It's a part of Brady. It really should be turned over.
It really shouldn't be hard.
It's really hard here, unfortunately. It's something
I'm
we're
sorry
fighting
to hear that.
about. We have a neighboring jurisdiction, DC, that just makes it automatic that those types of things are turned over. And so I want to see us kind of mirror that type of transparency. I think it's good for policing. It builds trust between the community and the police. And it's good for the overall practice of law. So that's my number one thing I want to see change, like ASAP.
I like that. The thing I really respected with Jackie Lacey is that she was my boss when I was the LA County DA. She put all of the declinations, so all the cases we declined that involved officer-involved use of force, those were publicly available. So you could see the reasoning behind it. Most people, I don't think, were aware of it, but that was all made really transparent under her. And I was like, you know, there should be an understanding. People aren't always going to agree with why the office does what it does, but to be able to say, no, this is why we are prosecuting or not prosecuting this particular incident or this use of force, all of that was made publicly available. And I think that there wasn't an awareness of even how to interpret that information, which I think was the next part of the problem. For me, what is one thing I would like to see? I think ease of jury service. Jury service is so vital to criminal law, and it is so onerous for people depending on where they live in the counties. And I think there's a lot of misunderstanding about how that works. But without a diverse and willing jury, you don't get good jury outcomes for people. And so I think that that's one of the things that can be streamlined. But that was particularly an LA County issue because LA County is so very large. I don't know how much of an issue that is in other jurisdictions. And we had one more. Go ahead. I didn't hear you, Natalie.
Jury service is definitely a problem. You know, for us in our county, the circuit court, which is where jury trials would happen. So we have two main court complexes. One is in Hyattsville and one is in Upper Marlboro. Hyattsville is closer to DC. It's close to public transportation. It's really, really easy to get to. That's a district court, right? It's like a criminal justice complex. It's got the police station. It's beautiful. It's nice, but it has no jury trials there. Where they have the jury trials is the county seat. And the county seat is off of like this river where they used to like do commerce and stuff like that. That's overgrown and floods, and no one actually works there anymore in Upper Marlboro. And it's basically like deserted. And all that's there is the courthouse, and no public transportation really goes there. So, you know, there's like a bus that comes by every so often. So we have a huge county. Our county is humongous. And if you live on one of the outlier parts of the county, getting into Upper Marlboro, or if you live in DC, is going to be nigh on impossible, especially to get there by 8:30 a.m. for jury service. So it's very difficult for people to participate in the process, and it's a problem. You need a diversity of race. You need a diversity of socioeconomic background. Everything. So
you absolutely do. We've got a few more super chats I'm going to shout out. Thank you, Stort Tamaha, who said anti-M. I sure appreciate it. Sarcastic Superhero Girl said, so great to see EDB and Natalie together. So excited to discover Nate. So Nate, you've got a new fan. Bridget said, I love Judge Middleton. I think we all enjoy the sass of Judge Middleton. And then Lynn has one other question about how do you guys feel about mental health courts as they seem to be becoming more common, effective in diverting people to more appropriate response, or not so much? So who wants to go first?
I'll go first. Oh, you go ahead.
It's interesting because I have a little experience in this when we had for prostitutions, which we had a diversion program. So because when sex trafficking became a huge thing here in New York, we found that a lot of people who we were arresting a lot of the prostitutes, and they were being sex trafficked. So the Bronx DA, which I think was phenomenal, had a diversion program where if someone was arrested for prostitution, it wouldn't be a criminal conviction. We would do a program in which we'd send you to one of these, I don't want to call them halfway houses, but they were programs in which, they'd give food, work, all that type of stuff to get them out of the life and they were trying to really solve the back end problem to why these people needed to do this to survive. What are the underlying problems to get you out of this situation? And we found that a lot of these women, actually, we kept going up the chain. So you would find like drug dealers, you would find like people with trafficking guns. We just had so much we were finding just because we were actually helping these women who were actually victims within the system. Instead of making them criminals, treating them like the victims that they were. So now they're trying to do that with these mental health courts. We're saying, well, these people who have these mental health issues, we shouldn't be treating them like criminals. Maybe we could do kind of the same thing. So I'm all in favor for it, because I think us in America, we always think about lock them up for a long time. That was always the mentality of the political class here. And now the mentality is there can be something different, because for too long of a time, that was used just against people of color, Black and brown, to really in the South, and especially in some places here in the North. But now I think as people start thinking about criminal justice, not in this, in the way of it being retribution, but more about rehabilitation and trying to get to the underlying issues. I think mental health courts are something that's long overdue. And I think if someone is having a mental health crisis, I think the courts and the police now aren't just able to deal with them because they just don't have the training. But I think if you put the resources in, it should number one, destroy the caseload, because a lot of those cases are just people who just have mental health issues that are just undiagnosed. And then it should also, I think, for society as a whole, you're starting to treat people for the illnesses and not like criminals.
Natalie, you get to deal with defendants. I'm sure you see it all the time.
Yeah, I mean, Nate brings up some amazing points. I'll just kind of add some shades from my experience. Everything that he says is right. In addition, there are some problems with mental health court. I've had a lot of experience with it. So the first problem with it is that mental health court, drug court, youth offenders court, all those type of things. So they have all these type of diversionary programs. So the first is that they are usually very limited in what they will allow people to enter into mental health court for. You can have a client, I can think of one right now, who is severely mentally ill, but competent. So, they're no longer going to be held in a hospital. They're going to be proceeding to trial. Every lawyer's dealt with that. This guy is mentally ill. He's competent. Was he competent at the time that he did this? Then there's these different questions about, whether or not he can plead not criminally responsible or insanity plea or whatever the case may be. When someone has a really, really serious charge, a lot of the times mental health court won't take them because they disqualify people for more serious charges. Another thing is that when you are that mentally ill, it's hard for them to comply with the conditions of mental health court. So sometimes people can be so mentally ill they can't get through mental health court. But technically speaking, they are not what we call NCR or eligible for what's called an insanity plea, which is what our NCR is, right? So you can't get them out that way. And now you're taking this person through trial who was really severely mentally ill at the time that this thing happened. So, and by that, so what I'm saying is you could be, for example, super mentally ill, eligible for mental health court because your offense does not disqualify you. But when you go into mental health court, you can't comply with filling out job applications. You can't comply with going into therapy because you're psychotic. You have psychosis that waxes and wanes and comes and goes, or you have such severe depression that you're avoidant. And so you can't participate, and that will violate you and get you locked back up. And then that snowballs into the third issue I have seen with mental health court is that sometimes if your client is able to get through a plea, the process will be over for them faster than if they go through mental health court and continue to get sanctioned. So for example, say they're facing misdemeanor assault and their normal sentencing guidelines would be like a year in jail, but instead of being in jail, they're in mental health court. They haven't pled guilty. It's a diversion program, but it's taken them like 2 or 3 years to get through mental health court. Whereas if they had just gone to jail for the year, gotten out on parole after 6 months, if it's a nonviolent assault, gotten out on parole after 6 months, and then been on probation, they would have been done with this case already. So those are the issues that come with mental health court, but I am for mental health court. Those are just some issues that they have, but by and large, for the people that are qualified to be in it, it's a great option to at least have it there. And then just discuss with your client, like, look, these are the issues that we can run into with this. Are you sure this is what you want to do? And if it's what they want, it's definitely what I encourage, because it can really help people to stay out of the criminal justice system once they work their way through the program.
Natalie, can I ask you something? Well, can I ask you about your mental health courts? Like for us, when they plead guilty, like they have to plead guilty to go to the diversion program. But after that guilty plea, we usually dismiss the charges. So the charges are dismissed, and after 6 months, it's sealed. So, and that's the way for us to not give them a criminal record, because it's kind of that give and take. Is that do they allow that to happen in your mental health courts too, or is it you plead guilty and you still have that criminal record?
No, because it's a diversion program, that means they're diverting you away from a guilty finding. Okay. So for mental health court, unfortunately for us, we don't have mental health court in our circuit court where the felony charges are. We only have it in our district court. So that sucks. You know, that's something we're working on. We're trying to get into circuit court. But what they do is they put the case on what's called a STET docket, which is for your viewers. It's Latin for on the shelf. They put it up on the shelf for the period of time that they're in the drug court or the mental health court. And then if they successfully complete it, the case is removed from the STET and it's null pros, it's dismissed. Okay. And then they can get it expunged from the record.
That's what LA does too.
There, so that you don't have the guilty plea while you're in mental health court, so that you don't have a hard time like finding a job and stuff like that.
All right, perfect.
Yeah, Natalie, you bring up a good point that I don't think is discussed a lot outside of really criminal attorneys, is that sometimes the best interest of the client might be the shorter period of time and not going through diversion programs. There were a couple judges that I worked with, particularly in drug cases, would let people plead open to the court and be like, okay, I'm suspending 15 years. And the defense attorney's like, we're not going to do. And they're like, yes, Your Honor, I have got this. I will plea open to the court, suspend those 15 years. I'm never coming back. And the defense attorney's like, no, please don't do this. And the judge is like, that's what we're going to do. So there's a lot of times when we're looking at what programs offer, but what's in the best interest for the person that's in court, knowing their history, knowing their likelihood of completing something. And you bring up a lot of those problems where people are like, no, the reason that you're in this court is also the reason that you might fail in this program. And then you're back to ground zero. And that might not be what's best for you. And I think that's a really good point. And that happens. I had more experience with drug courts than mental health court, because in LA, mental health court went out to a different department and was just run all through that department with dedicated counsel and ran with the hospital. But with drug courts, you would just sometimes be 2-3 years, people still trying to comply and then coming back and still being in the process when they would have been done with the case and moved on much quicker. So thank you for bringing that up. I absolutely, all points well taken. We had questions about a murder book. I'm sorry. A murder book is what we in LA called the entire case file on a murder case. It had all of the police reports. It was a binder that we gave to the defense attorneys, all the police reports, all the records, all the autopsy reports, and everything just turned over. So we all had the same stamped. So it's like, if the defense attorney's like, there's no page 7, it was really easy to go, okay, well, here's page 7. So that's what we called it. I don't know if that's what they call it in other jurisdictions. Natalie's like, no, it's not.
No.
Really?
I figured it out for context clues, but no, we don't call it a murder book. We just call it discovery, and it's based stamped, and that's it. Yeah.
Yep. It was the binder, because they were the only cases that really came from the police departments in binders. So it came in a binder. The defense got one, the DA got one, the detective had one. If you needed to, you could all sit down and go through it together. So that is how we refer to it. It's again, the way people refer to things in different courts and different jurisdictions across the country is going to be different. So I wanted to ask both of you about the types of cases that you cover on YouTube. Natalie, you were doing a lot of sovereign citizens. Can you just give us a moment and describe sovereign citizens? Because I have not talked about it a lot. I've had some sovereign citizen cases as a prosecutor. Have you had sovereign citizens yourself in practice as well?
I've tried.
They don't recognize your authority.
No, they will not accept my representation. I literally would have like sovereign citizen clients that would be like, I'm not speaking to you. So waste your time all you want, you know. Absolutely. But no, they usually don't retain the services of either private counsel or a public defender. But so a sovereign citizen is an individual you have like kind of like two breakdowns of sovereign citizens. The first one's like I would call like the original sovereign citizens believe that they're not subject to any laws of the United States. They are their own entity and they do not have to follow the laws of the United States. They kind of pick and choose what parts of the Constitution that they want to follow. They believe in like international treaties applying to them somehow. And in effect, what it means is that they don't have to, in their mind, have driver's licenses. They will take over property without purchasing it or signing a lease because they don't feel like they have to do those things. They just basically, they don't have to follow any of the rules. They don't need a license plate. They don't need insurance. It just manifests in a whole bunch of different ways. Another subsection of the sovereign citizens is the Moorish Americans, who are kind of like the Black sovereign citizens, and they have a more interesting kind of thing because there is the Moorish Science Temple of America that has nothing to do with the ones that I react to. Basically, they're a religious belief. They have their own civic beliefs, but by and large, they're pretty harmless. Like they just, believe an factual thing about the history of Black people in America, especially American Black people. They don't think that they came here through the transatlantic slave trade. They think that they're indigenous to this country. And so as a result of that, now we're talking about the more sovereign ones. They don't think that they have to follow the laws of the land because they are indigenous and basically they're their own nation, right? And the effect is the same. No driver's licenses, a lot of the times not signing leases, a lot of the time squatting in other people's property, driving around with no insurance. And so we get a lot of them during traffic stops that, they don't have license, they don't have registration, they don't have insurance. And so when they're stopped, usually for having, a license plate that says I'm a Moorish, sovereign on the land, instead of saying XYZ123,
right,
they get stopped for that. And then they don't have a license. And a lot of times they get their windows busted, or they get arrested, or they get tased, or they get maced, which,
well, they don't respect I don't want to say respect in the way of like having respect. They don't recognize that police even have the right to stop them. And they're like, you don't have the right to talk to me right now. So
yeah,
a lot of those things tend to escalate quickly because the police are like, but I do though. And they're like, but you don't though. Right? And then it just, yeah.
And they have different definitions of everything, right? So they're not driving, they're traveling. Because, we have a constitutional right to travel, but that's not what that means. It doesn't mean that you get to drive around with no driver's license. It just means that you can go from state to state without having to like pay for admission to each state, basically, right? So you have a right, and you have a right to travel, sure, but the mode of transportation is regulated by your local DMV or MVA. So that's one of their biggest chief beliefs, and they rely on outdated statutes, outdated case law that's been overturned since then, or misinterpreted case law. They also like to rely on the United States Code, even though they're sovereign to the United States. They're their own separate entity, but they try to rely on the United States Code, but they use the traffic article that applies to commercial travel, which is like CDL truck drivers. And they try to apply that to them in their like regular car and stuff like that. So it's a lot of fun. It's a lot of fun to be like, see this case they cited to, it has nothing to do with driving or not driving. Right. It's about this other thing. And they don't know what they're talking about. And it's just like fun to like break out the case law and talk about, nerd out on that. So that's kind of what I do with it. I like to come from it from like, yes, let's laugh at, this person acting a fool and saying crazy things, but also legally speaking,
here's the facts.
Yeah.
I had a sovereign citizen case that dragged on because they had stolen a house. And they had stolen a house in Santa Monica, California. The house had been open for open house. It was furnished. The owners of the house were trying to sell it. And they were like, this is a lovely house. And it is now mine. And they went and got a quitclaim deed to the house. They sent a check to the realtor in like a Dropbox that said, drawn on the bank account, entitled to me and every U.S. citizen held by the United States, and wherever. It was like a hand drawn on a piece of paper. Like, no, every U.S. citizen, every natural born U.S. citizen is entitled to this money that's held offshore. Somehow that makes sense. And so I've purchased this house from you with my money that the U.S. government's holding for me in the Bahamas. And so here's my money and I'm moving into the house. Got a locksmith out. Was like, no, I have a quitclaim deed. The locksmith changed the locks. And it was this people are like, what is your case? I'm like, well, it's a theft of a house because they've stolen the house. And it was just and then title got muddied, which is hard enough to clear title and sell homes. It delayed these people in selling this home where they were now paying 2 mortgages for almost a year and a half dealing with trying to get this person out. And of course, then they had done damage to the house. They were using the restroom after the water got turned off, after the power got turned off. And so it became this whole thing. But at the end of the day, I'm like, they tried to steal a house and it worked for a while and it was bizarre. But that was my entree into what are sovereign citizens. And the detectives were like, listen, let me explain to you how this works. Because it wasn't super common in LA County. It came up on occasion, but it didn't come up a ton. Nate, what about New York? Any run-ins with sovereign citizens who are like, you have no authority over me. I don't even belong here.
Well, I have a current case with the house.
Really?
With some sovereign citizens that can't get out the house. Now, it's weird because, all right, so
it's the property is just, and it becomes such a mess so fast.
I can't go into too many details, but
because you have a case.
There's a house in Queens, and we were set up right before COVID to get these people evicted. Right, we own the property. Right, no. We're going for an eviction. Right now, New York is very, very friendly to people who will squat in houses. So if you've been in there after a month, then it's like you got to go through the whole eviction process, like if they were just like an actual tenant. So it's like insane. So we were setting up to do it. Then COVID hits, and there was a moratorium on evictions. So now these people are still in there till today, believing that their sovereign citizen, whatever, has worked, and that's the reason why they're in the house. So we're just praying the moratorium ends so we can just at least get them out the house and get everything moving. So
man,
it's crazy. It's crazy. But that's but in the only ones that I've covered on YouTube was Kent Hovind. I don't know if you guys have heard of him. He's a big creationist, religious zealot, and he's like a sovereign citizen. He went to jail for like 10 years for not tax evasion, for I forget what the name of it, when you put more than $10,000, when you take $10,000 in cash and put it in the bank and keep putting it what's it called? Structure.
Money laundering?
No, it wasn't money laundering. Like what he was doing was that if you go to a bank, I used to actually be a teller. When you go to a bank, if you deposit $10,000,
Nate, every time you're like, oh, I just had this other random job, I'm always like, wait, what? Nate's like, I've done all the things. I love it.
But the way I think is that it's called we called it, I think it's 4789. And what it is that if you go to a bank and you have $10,000 in cash, it's an anti-money laundering law. So if you have a whole bunch of cash and you hand it to the teller then supposed to fill out this Bank Secrecy Act form to let people know that, hey, this person just gave me this much cash. And that's a way to have a paper trail of the cash. So now to avoid that, people will then say, well, I'm not just going to put $10,000 in, I'll put $9,000 in. So what Kent Hovind was doing was saying, well, I'm only going to do $9,999.99. So the bank doesn't fill out the form to let the IRS know that I'm depositing this money. But that is illegal because in the law it says if you structure your deposits
to avoid reporting,
filling out the form, then you're breaking the law. And he did it something like 100 times. So obviously structuring and then tax evasion and all this other stuff. So, so he then sued the government, he sued the prosecutors, he sued everybody. And the lawsuit's still going for, I think, about $10 billion. But it's on the channel. It's a weird sovereign citizen case. But I try to stay away from it because, to be honest with you, I like crazy, but I don't like too crazy. And the sovereign citizen...
It's fair. The Jen Shaw, so Real Housewife of Salt Lake City, Jen Shaw got federally indicted for this a huge telemarketing scheme on wire fraud and money laundering and conspiracy to commit the wire fraud. But part of the money laundering was the structuring because it was doing cash deposits and offshore deposits in amounts to not trigger the reporting, which is one of their key components under the federal money laundering statute. We have a lot of super chats, and I feel like we are way behind in questions, but we're having such a lovely chat. I'm sorry, you all, this happens. Scott says, if the court docs are stored and used electronically, the blockchain should be used so documents can't be altered like it can using PDF. Generally, when documents are going from detective and prosecutor to defense attorney, it's not that much of a huge concern, but I think it's a very interesting potential for use of blockchain to make sure that things are authentic. I think blockchain technology might be really interesting with cell phone evidence and video evidence, because now we're seeing so many and such readily available deep fakes. I think it's going to get very interesting to prove that video and stuff's actually authentic down the road. So do you guys have any deep thoughts on criminal law and blockchain technology? Because we have a lot to get to. Fair enough. I think it's going to be an interesting way to go, because you're going to get people saying that's not me on that video, that's deep faked, and having to track back and prove how the video is authentic, and really track and authenticate digital evidence is going to get very interesting here. Catherine Stevens, thank you for the super chat.
That's my girl, Catherine.
Thank you for coming in. Awesome. I love it. Natalie, what's your Natalie squad? What do they call themselves? What are the Natalie lawyer chicks?
No. I just I'm starting channel membership next week, and I'll be calling them like my 1Ls, basically. You know?
I love that.
And I've explained to them what that means, but that's what I'll be calling my channel members. But yeah, no, they don't have a name right now.
Y'all, if you don't name yourselves, Natalie's going to start calling you the chicks, or it's like the Natalie lawyer chicks, and they're just going to follow you around the internet, and you can be Mama Natalie, and they'll just. But you guys, they're just going to be your chicks because you're Natalie lawyer chick. Y'all, Natalie's friends, you guys, name thyselves. Come on. The law nerds are going to make suggestions, I'm sure, in the chat.
Okay, that'd be
great. Nate, what is your crew? Are we Nate Squad? Broad Squad? What?
The Brody's Bunch.
Brody's Bunch.
Yeah. So
I love it. Natalie, we're going to name your community. We're going to name your community.
Okay. Yes.
Yes. We are. We're calling them something so we can see them in the chat. Lynn said, thank you for your discussion of mental health courts. After years as a mental health social worker, it's nice to get the legal perspective. Appreciate you. Thank you, Lynn. We appreciate you too. I think one of the really important things about having open conversations is that oftentimes those involved in law enforcement, the people who really are dedicated to it and being part of the criminal system, we all want it to be better. Like everybody wants it to be better. We have different views on maybe sometimes how to make it better, but everybody's like, no, this shit's not working. We need to make this work better, because the stuff that's really bad, everybody's like, yeah, it's really bad. That is a danger to society. And the stuff that's not bad, we need a better way to deal with it. So I think that's what's nice about having the conversation about it. And Natalie, I'm going to ask you a question in a few minutes about Josh Duggar. Have you followed that case at all?
Yeah, I did a live stream on it, and I'm gonna do a follow-up. I saw that you covered him getting bond, so yeah, let's talk.
I want to talk about the bond, and I want to talk about the police taking his cell phone as evidence when he was asking to call his lawyer, because I think we might have some interesting evidentiary issues on stuff that came after that, and I wanted to get you and Nate's opinion about it. So let's do that next. Eva said, speaking on mental health, are y'all afforded to take care of yourselves mentally? I've gone back and forth on law and psychology. I think the former is needed more at the time. So at the LADA's office, there was we had healthcare, but there was no real provision for mental health care. That might have changed in the 4 years since I've left, because I think in practicing criminal law, you kind of need that support. I don't know. Is that different elsewhere for you guys?
I know here they were very concerned about burnout, because it was a lot of long hours, and you have young people who this may be their first actual real job coming out of law school as an ADA. So they had some systematic counselors and stuff in place. So I think they were a little bit more attuned to it, because especially too the Bronx and Manhattan, they've you had a lot of stuff going. You got 1 million people in the Bronx, and I worked in Brooklyn. Yep. You got the largest DA's office in the country's in Brooklyn. So, just with that much work and stuff, people just get burnt out. So they did have a nice little system in place to help us out.
I'm going to have to Google, because LA County says it's the largest DA's office in the country. So we're going to have to see, because LA County is like 40 million people, but It's a huge office. It covers 40 plus courts. I mean, it's a huge office. People are like, do you know so-and-so? No. No, there's thousands of us. I don't know LA County is huge. And you had to cover, when you got hired with LA County, you could live at the bottom of the county in like Long Beach and have to go to Pomona or Antelope Valley, which are on the far ends of the county, and be driving 2 hours to work, particularly if you maybe kicked up and misbehaved. They call it freeway therapy. They're like, oh, adorable. You're fighting with your boss. You have earned yourself a 2-hour commute each way. Enjoy that, counselor.
God. Sounds horrible.
Problem with a big county. Copywriter here. Stet is actually Latin for let it stand.
Oh, okay. Thanks, copywriter.
It's the hopper. It's the hopper. It's you put it in the hopper where it waits. I like it. Waiting on the docket. I have lost a few other lawyer super chats, and I'll go find them because I know that Creep Show was here. Hello, Creep Show. Thank you for coming in. It's so good to see you. And my mods are reminding me that I haven't reminded you guys to do the YouTube-y things. So before we get any further, like the video, but more important than that, go make sure that you are subscribed to Natalie Lawyer Chick and Nate the Lawyer's channels for their coverage. We all cover, sometimes our stuff intersects, sometimes it doesn't, but we all have a different perspective on the stuff that we cover. And Nate's got a video about the U.S. women's soccer team. Did you expect that video was going to be hitting 600,000 views? Like, what is happening with that video, Nate?
Well, it's actually someone, another YouTuber said, well, hey, Nate, because when I first did my first video on that, I got 100,000 views, but I only had like 5,000 or 6,000 subscribers. So then when I got like the 60,000 subscribers, somebody said, well, you should just, repackage it and do it again. So I said, okay, what's a good video? I'll repack. And I repackaged, literally just took the same video, added some different graphics and some different words, put it up again, and it got 6,000 views. So I'm like, now if I get more subscribers, I'm going to repackage it again.
You're like, that video's the go-to. Were you surprised that that one took off?
Yes, I was surprised because the problem is that it seemed like people were just confused on the facts. And
so often the case.
Yes. So it was just like, it was just like, let me just lay out the facts and just see how people, and it just took off like wildfire because it was more, the video wasn't really about debunking anything. It was just like, hey, what's actually going on? And just being able to answer that question for people on the right and the left, it was just like, okay, this is what's going on. And it filled that little niche. So I was surprised that it was less of me giving my opinion, but more only just introducing people to what's actually going on. So that's why I was
Natalie, have you had a video that has taken off that you've been surprised about, that you've been like, really, that? Okay.
Yes. When the lawyer who was on Zoom yelling at the court and her client and saying, my client's mentally ill. And the judge was just
she
like,
threw her client under the bus, got in the bus, drove the bus, and backed over him again.
Yeah. And I have so many videos of things like that happening. But for some reason, I mean, I guess it was when, and then she's like, I bet you I don't come back again. And the judge is just like, I'm holding you in contempt. Well, so what? I don't care, Click, hanging up the phone. I mean, that one, yes. I mean, it was crazy what she did, and it was completely out of the norm. And whoa, but I just can't believe how much it blew up. Like, I'm trying to figure out like how many people, like how many views the video has, but it has like way more than any of my recent videos. And I still get comments on it to this day. And
so people are still finding it.
Yes.
Yeah.
Yes. New people are commenting on it. And I'm just like, where did you come from? Where did you come from? I think it has like 307.
No, that has over 300,000. Yeah, I just pulled it up on your channel. That has over 300,000 views. So it's probably still trending in those keywords. And I bet you other videos have referred it to, because I know I've talked about that video and I'm sure others have talked about the video. So when they find a video that refers to it, they end up coming back over. But in your backend analytics, you can see referral sources and you can deep dive into them, which I didn't know until today. And I was watching one of my videos. I'm like, where is this getting traffic from? And it was like Facebook Messenger and Gmail. I'm like, oh, people are sharing this with people. That's interesting. So you can go and dive into those analytics and look at where people are coming from, because that's so interesting to me to see.
Well, I want to. There's I think I have the name of the service. I'm not sure if it's vidIQ or something else.
It's vidIQ because I'm a vidIQ creator.
Right. We'll go with vidIQ. But one thing they do is that they let you when you pull it up on the side of it's a browser extension, and it actually tells you like how many people have tweeted about it, how many people have shared it via I forget, Reddit and all this other stuff, and you can click on it and see like
oh, look, Natalie, can I pull it up and show you?
Yes.
Can I pull up your video and show you? Is that
Yes.
totally dorky? Sorry, guys, we're
No.
gonna geek real quick. In the chat, though, the chat feels strongly about a Natalie Squad name: the Nat Nerds, the Chicks, the Chickettes, the Chicks, the Lawyer Chicklets. Oh, I love the Chicklets.
The lawyer chicklets.
The Lawyer Chicklets. I love, or the Law Chicks.
Love that.
I love the Law Chicks too.
I would like chicklets because it doesn't seem as like women only, and a lot of my viewers are men, you know.
Inclusive.
And like
the
a
chicklets.
chicklet is a gum, you know. So
and they found you. They found you. You need an emoji so that when they show up in the chat, you guys, chicklets. Show your Natalie love in the chat with your emoji, because having a channel emoji means people can kind of show their love in the chat, which I love. Look at this. Amazing. The Law Chicks. I love the Law Chicklets. Also, Chickadees got suggested, or Chuckadees. I'm going to go with Chickadees got suggested. Law Chicks, Law Chicklets. Natalie, what say you?
Law Chicklets. Sure. Yeah. But Law Nerds isn't good. Only thank you for the suggestion, but it doesn't work because that's Emily's people, and it's like, no.
It's specific to me because I'm a giant nerd. I mean, and like I'm a Pokemon nerd, I'm a Doctor Who nerd, like I'm a Star Wars nerd, like I'm a nerd. Yeah, I'm just a nerd. All right, I'm gonna share we're gonna do like a real YouTuber like back end take a peek at Natalie's channel because she said yes. So this is your video that's amazing. The prosecutor, by the way, I love her keeping her shit together. Like I would have fallen out of my chair. The judicial assistant is trying not to die, and I felt for both of them. I felt for the defendant. I think the reason your video did so well is because you're a defense attorney saying like, this is not the best of our profession. This is not what we do to our clients. And it doesn't matter how difficult your client is. This is not what we do. And this is not how we do it. And I love that. So with vidIQ down here, you can see where it's coming from. And on this video, 93 Facebook shares. So that's gotten shared around Facebook a ton. And then there's 2 different Reddit posts, 26 Reddit comments, and 205 Reddit upvotes. And you can click on here and go see where it's getting posted on Reddit if you want to. And then you can, tracking down the Facebook's a little bit harder, but that's where a lot of that's coming from, is that people are finding it through Facebook sharing and then through Reddit posts. And you can go in and see which Reddits are posting things. That's not always advisable depending on what you're talking about, because sometimes Reddit is not kind, but when they like your video and you've got that many upvotes, you can actually click on that and go into the Reddit thread and see what they're saying about the video.
And a lot of times, you can also search your video on Twitter, and then with people who share the video, you can interact with them too. Because I like to do that too, just to, because it's another way to get people off platform, just so they can, just to get that personal connection. Maybe even just a like their share, and then people, oh my God, you like my, But it's good to at least let them know that you're looking too. So.
Yeah, I'm like, I need to like go back and rewatch this and stuff so I can take notes. Thank you.
You're welcome. I love this, and the chat is getting flooded with our chicks. So I love the love. Nate, do you guys use a particular emoji with the Brody's bunch?
No, well, I have my membership emojis, but I don't have a particular one. So I have to think about one now.
Nate, you need an emoji.
I need an emoji.
You need an emoji because we've kind of taken over the Purple Hearts crew over here when the hair went purple, and that's been really fun because when I'm now on other channels, I'll see the Purple Hearts, and you can see it really easily. And then the law nerds know, but yeah.
So I'm loving the purple hair, by the way. I did need to tell you that. I really love it.
It was really fun, and it's kind of nice. Because I'm, not being a DA anymore after so many years of working for the office, I was like, oh, like if I want to dye my hair purple, I actually can dye my hair purple. Like I can kind of do what I want. But when you're in public service, I mean, maybe it's just when you're a woman in law. Nate, you're going to have to tell us if this happens to you. Your appearance gets commented on so much. I've had my appearance in court commented on by judges, defense attorneys, other DAs, jurors after jury trial, defendants hollering things at me, and defense attorneys, knowing that I'm married and asking me out and whatever. but that happens on YouTube too. Natalie, you had a great video about that. And it's like, my appearance is not up for discussion, and my appearance doesn't alter my education, my experience. Because Natalie, I know you get that. Nate, do you get that? Do you get appearance up for discussion?
I do, but I get it in a weird way. It's because I don't look like a traditional lawyer, by any means. So,
but then what is a traditional lawyer at this point, right?
Thank you.
I expect you to have the tie and the suit and my hair be, perfect and short.
In your house?
Huh?
In your house, they want you to.
You're supposed to have the boring law books behind you.
Yeah.
Get some douchey law books. Put the douchey bro law books behind you, and then you'll be like a real attorney. I agree with that exactly.
For me, it's just like a lot of people. They have to be almost convinced that I am an attorney. So and after 5 or 6 minutes of my video, you can say, okay, this guy's an actual attorney. So a lot of the comments that I get is like, you don't dress like an attorney, you don't look like an attorney, that type of thing. But I think it's more microaggression than anything. But generally, and obviously, as a minority male in this profession, there's just not a lot of us doing this, especially at this level or even on YouTube. And I think that's another thing, because at one end, I'm introducing people to a Black lawyer, but on the other end, if this is their first interaction, it's like, it's weird, because I want to be a good representation for people who have not been introduced to attorneys who look like me, but then I also want to be true to myself and true to the medium. This is who I am, and this is what I want to produce. So, I've had a couple of issues with that, but in court or anything like that, no. The worst thing I've had in court is one time I came without a tie. No, I had like that little Texas tie, and the judge reamed me out like, you got no tie on. I was like, this is a tie. No, it's not a tie. That's a piece of string. Get no tie on to my.
Your Honor, it's fashion.
Right.
First we have.
But you raise a great point, Nate, is that people are like, oh, what's a traditional lawyer? You're not a traditional lawyer. And it's like, oh, is it because of my race? Is it because of my hair? Is it because of my gender? Is it because of my hair color, my tattoos, the way I wear my hair? I think that the problem is that when they say traditional lawyer, what they mean is kind of a 50s, 60s-ish old white dude. And so if you're not that, that's what they meant. And I love that you're like, no, I have an education. I have a fuck ton of experience. I am who I am. And Natalie, you get that on your channel too, don't you?
Oh, yeah. I mean, I think people have a hard time realizing that being an attorney is not central casting. It's education. It's an education plus.
Wait. One more time for the people in the back. Being a lawyer is not central casting. It's an education. Yeah. I've never heard it said that way, and that's exactly what it is.
Right? So it's like, I'm not here to fulfill whatever you traditionally think a lawyer is or is not supposed to look like. I am here, forget YouTube, in my practice of law, I'm here to represent my client and to advocate for my client. And please underestimate me based on how I look. I beg you, please do that. That would be great. I get a lot of it. I remember this once my channel started to get some views, I was wearing this dress and my bra straps slipped out, and you could see it for most of the video. It's one of my bra straps is out and she could see it. And this woman lost her mind over my bra strap. She was like, how could you be a lawyer and have your bra strap showing? What's wrong with you? And she commented it under my pinned comment. And I was like, I'm going to ignore this. It's whatever. It's fine. Then she commented it 3 more times in 3 different comments. And then she went to other videos and started, in your video that you posted today, I can see your bra strap. And that was one of the things that triggered me making that PSA video, because I was like, first of all, you have lost your natural mind. You're crazy.
Yes.
Let's be real. It's not a normal thing to do, to troll someone over a bra strap. But
guess what? Women oftentimes will wear bras.
Yeah. Look at that.
This is
what? If you don't wear one,
they're going to comment too. That's a huge problem.
That's a problem, So sorry, Nate, but it's a problem. So I make it very clear, and I've made it this way from the beginning of my professional life, and that starts with law school, that as long I dress professionally, of course, you're not going to be able to see any of my body parts, especially when I'm in court. Everything is, covered up, but I'm not wearing a blue suit with pinstripes and kitten heels. That's not me. Yeah.
Pearls.
Oh, pearls. Yeah, I'm not wearing pearls. Okay. And I'm not carrying a suitcase, and I'm not wearing a suit that's cut for a man. Okay. I am a full-size woman, and I'm going to dress like that. And that's just what it is. I started my dreadlocks in law school. I remember when I started them, a Black woman took me aside and was like, that hairstyle is going to be inappropriate for the practice of law. Like, that's not an appropriate hairstyle. I was like,
I got that too.
And I was like,
yeah.
Watch me. I was like, this is how my hair grows out of my head.
You need to change that. That's not appropriate for the practice of law because it's hair.
Exactly.
Yeah.
And just to be totally like, to bring it home, there was this young lady that I went to like a lawyer's brunch with or something like that. And we went to this lawyer's brunch, and it was like, you know, a bunch of young lawyers, and this was like pretty early on in my practice. And here I am with my dreadlocks and my bright colored dress and all this other type of stuff. And there was this other girl who was very more traditionally dressed, very beautiful girl. I mean, my goodness, I just shouldn't say girl, she was a woman, but we're the same age. I couldn't help it. So, you know, So beautiful young lady. And she was also, you know, African-American. And she had this hairstyle that like was very long and like straight and like waved and layered. And it was just like beautiful. Right. And she was upset at the brunch because that morning in court, a female judge had pulled her aside and said that her hair was too colloquial. Her hair was too colloquial.
I'm sorry.
That's not the hair of a woman professional, of an attorney. And her hair was Eurocentric, because, you know, that's what I was told, is that my hair was not straight and my hair is not, you know, traditional, and it doesn't assimilate. It's not Eurocentric, so it's not going to work. That's what I was told by a woman out of concern told me this. She wasn't being rude.
Right.
That's what she told me. And a judge out of concern is telling her that your Eurocentric hair, it's too styled. It's too colloquial. It's what a woman would wear out to a club. It's not what you would wear. And all it was, I feel like a white woman with the same exact hairstyle would not get that much flack. And that's not to say like, oh, you know, I have colleagues, white female colleagues, who have a little streak of color in the back of their hair.
Oh, the world may end. The world may end.
Let a Black woman do that.
I mean, right.
No, you're right.
The world would absolutely end.
Yeah.
And you'd get called in by a boss.
Mm-hmm.
Yeah.
So I just embraced it. I was like, this is how I look. This is how I'm going to look. You know, if you don't wear makeup, oh, she doesn't take care of herself. If she does wear makeup, she's too vain. So you know what I'm gonna do? I'm gonna wear makeup, and I'm gonna wear nice clothes, and I'm gonna wear nice shoes, and I'm gonna wear colors. Yep. And they'll be in the same, you know, it'll be a suit, right? Technically. But I'm gonna look how I look. And so that's the approach that I've always taken to. And I always said, if a company won't hire me because of how I look, then that's not where I want to work. You know, I've never had a problem getting a job, so I'm good.
And it doesn't, I mean, your legal education is not affected by if you put on mascara that morning or not. But then you get, I mean, are we tired today, Miss Baker? Yes, Your Honor, we are tired today. My child was up all night and I managed to get here relatively on time, not covered in throw up. So yes, I'm tired. Am I not smiling this morning? Miss Baker, you're not smiling this morning. I'm sorry. Am I supposed to smile? I'm sorry. I'm supposed to smile every time I come into court. But then a different court, it's like, Miss Baker, is something funny? You're just sitting here smiling. I'm like, oh, my bad. This is the women shouldn't smile court versus the I should be more chipper court. My bad. I have forgotten. And that's not all courts, but you could see it. And I worked in DC for a summer, and there were definitely moments of, oh, well, you're wearing pants. You should be in a skirt. I'm like, I'm sorry, you haven't met my thighs. We're not wearing a skirt in DC in the summer. I'm from California. I don't know humidity. This is what we're not doing. So it's very interesting how kind of the profession and then YouTube can kind of parody the same stereotypes and the same biases and the same aggressions of this is what's said in court. This is what's said in professional. And I'm hoping that by being different and on YouTube, people's idea of lawyer changes and that they start to see, oh, lawyer is a profession and an education. It's not someone who looks like this. And we definitely saw that in LA early on with like the Ally McBeal and all the LA law shows. It's like short skirts, high heels, long legs, fit body. Like that was the stereotypical lawyer. And the LA DA's office, don't tell my colleagues that are still there that we're talking about this. These are secrets. But when they put DAs into the kind of high profile units, appearance was a huge consideration because they might be on the news. There would be photos of them. They might be prosecuting high profile cases. And there was definitely a type. And I'm like, but good lawyers. And it's like, but TV friendly good lawyers. And that was always very, very interesting to me. So I love having that conversation. And I think your hair is amazing. So, I mean,
Thanks.
Have you ever had a judge be like, oh, that argument's invalid because I was distracted by your hair? I'm sure that's never happened.
Absolutely not. Absolutely not. I've had judges. That's so funny. There was a week where I was giving my skin a break from wearing makeup because I do that from time to time. Like I'll take a week off and not wear makeup that entire week because it's skin. It needs to breathe. Okay. And bless him, this judge calls me up to the bench on like Thursday, right? So it's been like 4 days of this. And he's like, are you okay? Like, is everything okay? I see you're not your normal self, you know? It's like you're always, he was very elderly too. He's always so, spiffy. And I'm just wondering, is everything okay? You know, I was just like, the way
I'm not going through it.
The way I cracked up on him, I was like, Your Honor, I'm fine. I'm just not wearing makeup. You know, I'm a little lighter under my makeup. I'm a little paler. The eye bag, you can see my actual age under there, you know, the acne spots, they're all there. I'm fine. Yeah. This is just human skin, you know?
Welcome to my face without makeup.
Yes. And I always make it a point to go without it for a while so I never forget what it really looks like, you know?
Yeah. I was very pressed about my image in my head about what a lawyer looked like in misdemeanor court when I was a new DA. And I'm dyslexic and ADHD. I had a lot of insecurity. So I was very much black suit, pearls, heels, like very buttoned up. Somewhere into my felony rotation, I'm like, I do not have time for this shit. I need to focus on my work. I don't have time for the insecurities. And there were a couple, both DAs and defense attorneys who were like, you don't have to like do all of this. Like it's clearly not you. And I was able to step into being myself a little bit more as I got later on in my profession. But that tilted up as I moved out of the government practice of law and into the YouTube conversation of law. A few more super chats. Eva said, I found out about Natalie from Artie and OPT, and this is basically the 360 degrees of Kevin Bacon. I love that. That's fantastic. We have lots of comments about your video talking about appearance and appearance not being up for conversation, which I absolutely love. Bridget Diesel said, my favorite Natalie video is the one where the ADA realized that the DV abuser was in the same house as his victim in front of Judge Middleton. That video is chilling. And I think it raises one of the issues with COVID because again, Natalie, as a defense attorney, were you watching that going, no, don't be in the house. Please don't be in the house. Because we're all watching it going, don't be in the house. Don't be in the house.
Oh my God. If you're a victim advocate, you're like, please don't let this actually be happening right now for her own safety. If you're a defense attorney, you're like, you are ruining my case. What are you doing? This is my case. What are you doing?
Yep.
Oh my God.
Absolutely. And that's one of the things that's been weird with COVID too, is this how it affects the entire process and how everything has changed and the awareness that has to come into the fact that things have changed. People are out. People are being monitored differently. And we were going to talk about the Duggar case with that because he did get out on bond and there was a lot of anger about it. And I caught some pretty hefty flack for saying it's a nonviolent crime. But I'm like, but you guys, I know that the thing, and I'm going to do this and then I'm going to do that because I'm going to jump. Stacy said, I just wanted to say you all look fabulous. Saw you on H3M. Loved it. Thank you. Longtime fan of Nat and just sub to date. Perfect. Welcome. Yeah, today was a weird day with the H3 Colin. It happened spontaneously. Larissa says, it's 2021. As a society, can we stop feeling the need to comment on someone's appearance online or anywhere? Really, or anywhere.
But she makes a great point because some people feel more free to say
Oh,
whatever they
bold.
want. You know, yeah, they feel bold. And like sometimes I have to remind myself, Natalie, you do not clap back at this person. Like, just calm down, just block and move on, you know? So yeah.
It's hard. It's hard sometimes when you're used to fighting in court to not carry out proving your case online as to why somebody's wrong, and you can prove to them why they're wrong, because it's not going to matter when they're an anonymous person behind a keyboard.
No. They win.
It's hard.
They
yes,
win.
they do.
Yeah.
So
you've given them all this feedback and then they've won.
Exactly. So when silence is the answer, it's hard for the lawyers that go into court to talk, and that's criminal lawyers go into court to talk. I liked doing trials. I really enjoyed trial practice. There was Natalie's like, not so much.
I miss it. No, I loved it.
No, yeah, loved it.
I haven't been able to have a trial in over a year. I am like having withdrawal. I miss trials so much.
Yep. And then the panic sets in of, oh my God, how many will there be? I mean, LA is starting to open up. So my friends who are still DAs, they're like, I am going to have I need a vacation. The pandemic's been hard. I need a break, but I am going to be in trial for 18 months back to back to back. And I have 17 judges going, when are we scheduling this? And it's like, I'm only one me, so I don't know. Yeah. So I'm sure you're going to be stacked up as well with trials.
It's going to be a mess.
Yep.
See, that's it. I just do pre-litigation now. So, you know, if somebody says trial, I'm running for the hills. No, the trial. We're looking to make a deal here. Trial, no, you know. But
see, I get to do it on YouTube. I feel like the skills of a trial lawyer, when you're a trial lawyer, if you can get a jury to like listen to you that doesn't want to be there, that is the toughest audience in the world. And comedians are like, our audience is the hardest audience. They paid to be there. They paid to come and sit down and have a drink. We dragged people off the street out of their lives. They don't want to be there. A judge has probably yelled at them for their answers during voir dire, and they hate the entire process, and the person next to them smells. And you have to get them to pay attention to you. At least on YouTube, they've clicked on your video and they're like, oh, I'm here for you. Mm-hmm. Getting a jury to listen to you is fascinating. But Duggar. So Nate, did you follow the Josh Duggar stuff at all with his?
I followed it a little bit. Obviously him getting arrested and the bond. I saw your video, and I saw just a couple other videos on it. But I'm really not a big Duggar fan, so you know, it's like this is getting a little crazy for me. Especially after the Ashley Madison thing. Then me and my wife had to have a conversation. Like, I don't know what this website is about. I've
never even heard of her, Ashley. Who?
I don't know Ashley.
I didn't follow the Duggars. I was like a John and Kate +8 person when it came to I followed that. So I follow my fair share of TV that is not redeeming to anything.
Can I just ask you guys one thing? 90 Day
Yes.
Fiance. Are you guys fans of 90 Day Fiance?
I don't watch 90 Day Fiance.
Oh my God, that's like such a that and the Housewives. I don't know why.
I'm a huge Housewives fan, but you know this.
Housewives of Atlanta. What Portia's going through right now is insane. I'm just going to say. Portia.
Whoa. I don't even watch that show and I know what she's going through. How about that? How about that?
That's
blown up.
Friend and
wild.
That's some shade right there. That's some shade.
Yeah.
I know people are like,
her friend's not divorced. She's not divorced yet. The divorce is still ongoing, and she's engaged to her friend's man. They're still married. That's her friend's husband still.
Yeah.
They're still married.
Yeah. Crazy, right? Crazy.
And I think she's pregnant too. Disclaimer, it's just my thing. It's just the pictures I've seen, the video she was dancing and she looked like she was pregnant. So that's it. I think she's pregnant too. That's crazy.
It's insane. It's crazy.
Just had right before that though. She had the stripper issue too right before that with Bolo. And now she's got the carat ring from. You didn't know about the stripper issue? Oh,
get into Bolo real quick. Get into Bolo real quick. We'll get back. We'll round back to Duggar. Get to Bolo. We got time. Go, Nate. Go. Yes.
So they had this bachelorette party. It was a stripper. Supposedly she slept with a stripper. It's insane.
The male exotic dancer.
Yeah. Male exotic dancer. Yes. So supposedly that happened while this friend was there, and her husband. She was actually staying with her husband during the trip. I just don't know what's going on in Atlanta. Yeah. But I'm thinking now they're just doing this to keep the show going, because I'm like, this is just really some insane stuff that's going on now.
It's a mess.
Yeah.
Like it's a mess.
Yes,
So
yeah,
it's a mess.
No, I am my wife watching. Well,
wait, no,
Lachelle
Lachelle in the chat has said 3 of them slept with Bolo. Like,
Is
I
Bolo
mean,
the stripper?
Yes.
Bolo's the dancer. Yep.
Oh, I was wondering what that term meant. Okay.
No, that's the name. Yes. But this is like the pirate on New York when everybody's like, Luann slept with the pirate on vacation. This was kind of the Atlanta version of Luann slept with the pirate. Yeah. I had not heard that 3 of them had oh my, we're gonna have to have a lawyers talk housewives at some point, apparently.
Yeah, absolutely.
It's wild. And they're not even filming right now. All of this coming out feels forced and fast. It's like, you don't have to come forward with this relationship just yet. Let the divorce go through. Like, let's give everybody some space.
He gave her
the only reason I can think that they're coming forward with the relationship is that she's pregnant, because they're not filming. So why would you tell people this? Why wouldn't you just keep it on the down low until the divorce is done? Because it's going to really hurt him in the divorce proceedings if he's like has a public engagement while he's
married.
All the lawyers are like, what are you doing?
Yeah. Somebody's very confident in their prenup. My speculation, someone's overly confident in the strength of their prenup to be acting like that.
Iron tight. Yeah.
Yep. The lawyers behind the scenes going, no. Take a note from the Kardashian divorce and shush.
Oh, that's a real hushed up divorce.
Yep.
But also one that we all saw coming for like ever, right? Like,
yeah.
I was surprised they lasted.
They've got a lot of kids.
Yeah, that does. Well, yeah, but it's like, it didn't seem to be very healthy there at the end. And he was like,
no.
When you start calling your own wife a white supremacist, and I'm not saying whether or not I think she is or not, I just feel like that's weird. Like, that's a weird thing to do, is like to call your wife a white supremacist.
I hadn't even seen that.
Yeah,
that's wild.
Too much. It's too much. Yeah,
absolutely.
That was ready to come.
The mods are letting me know we are getting an echo. I don't know where that is coming from. Did anybody turn their volume up?
Let me mute myself.
No, I'm muted.
Are we still getting it? Natalie, I don't think it's you.
You don't think it's me?
I don't think it's you. Nate, are you back?
I'm back now.
All right, now it sounds good. All right, if that picks back up, we'll figure it out. Thank you, mods and chat, for letting us know. Yeah. All right, for those of you that aren't familiar with the Duggars, I'm going to break it down because Natalie, you have watched the Duggars.
Yeah, I actually used to love that show. I really, really did. Genuinely, like, unironically loved it.
No, you're in a safe space. We're not gonna call you out for what TV you like to watch at all.
I love them. You can't say in the Housewives.
Yeah, we all look. Law is serious. TV shouldn't be. TV should be an escape, a fascination. I can't believe this is happening. It should not be heavy after the work days that you have in criminal law. So. For everyone in the chat who's like, what is happening? Josh Duggar was arrested for possession and receipt of CP. I'm going to call it CP. That is what the law calls it. I know that often people will call it images of child sexual abuse. We're not going to dive into the nature and the graphic nature of the case because that can be triggering. And if you want to watch those videos, you can. We're going to talk about the criminal procedure side of it and the release on bond and what have you. So he got arrested. What came out at the bond hearing is that this had been a 19-month investigation. There had been a raid to collect digital evidence at his place of employment. He had been out since then. He had not been charged. He was charged and then arrested a few days after like a day after, I think he was charged, and then was in custody, had a very extensive, from like 1:30 to 6:15 p.m., a very long detention hearing wherein one of the Homeland Security agents spoke, the defense attorney spoke, the people that he's living with spoke. Not the defense attorneys. They presented the one witness, and the pretrial services spoke. And then he was released on conditions. I know there's a lot of frustration that he was released on conditions, but he's released on home detention. that he's paying for the monitoring. He's released to a third party that he has to live with. He cannot live at his own home. They're monitoring him. They turned over the guns that they had in their house. They changed their home schedule because they had been teaching piano lessons. That's not happening in the house. No contact with minors and a bunch of other conditions, except for he can be around his own children in the presence of his wife only. No internet usage, those kinds of things. Natalie, what did you think about him being released on bond?
It didn't surprise me. Actually, when I did my live stream, I said, if he's going to be released, there's going to be conditions. He, doesn't have much of a criminal history. So blah, blah, blah. That's what should happen, actually, because it is a nonviolent offense. My only qualm with his release conditions is that he's allowed to have contact with his children under the supervision of his wife, because I don't think his wife would actually provide any real supervision. Like, he had this addiction while he was in the house with her, had what he admitted to was a P addiction, not the CP, but a P addiction, and had cheated on her and been discovered cheating on her. And then we know that he abused his younger sisters, and he admitted to that. So if she continues to have, I think they're on their 7th child or something like that.
She's pregnant with number 7.
Yeah. So she's pregnant with number 7. If she continues to have children with someone that she knows all this stuff about, I just don't believe that she'd really supervise him around the children. And I don't think the children should be risked like that. He should have to stay somewhere else separate from his kids and have like virtual visits or something like that. Like, not no contact, but no physical contact with his own kids. So, yeah, I mean, because it's not like he's acted on those impulses. He's acted on them. It's not like you just viewed the imagery and that's it. He's actually acted on it. So I don't think that's a good condition. But other than that, I'm fine with him being released, especially with, the COVID and everything like that. I just don't think that that's a good condition.
I wasn't surprised either, because there's no getting around his defense attorney's argument is that they asked the Homeland Security officer, so 19 months ago, you raided it and started pulling evidence and we're doing this investigation. If you thought he was a danger to his community between then and 19 months later, would you have arrested him at that time? And they're like, yes, we would have. And his defense attorney's like, ergo, he is not a threat to the community because he has been out for 19 months and they have not arrested him. And they had the digital evidence being turned over then. And I don't know if the court can really overcome the balancing when the investigating officer is saying, no, we did not rush to arrest him because we didn't see a threat to the community. I also, people get frustrated with it being a nonviolent crime, but this is a computer crime. He's not the one being charged with creating images. He's not the one being charged with doing any of that. It's viewing and receiving. So it is categorized as a nonviolent crime. And they're for a lot of nonviolent crimes, these are some onerous conditions, more so than you would see in other crimes, and maybe more so than you would see in this crime if he was not a public figure. I was surprised about the physical contact with his own kids because they hadn't done forensic interviews with his kids yet. So that concerned me too, because there's room for them to be swayed. But then the court's going to be like, well, what's different from the 19 months to now with his own kids? But it worries me because now he knows there's a knowledge that he's facing 5 years minimum prison time. So I think it changes the circumstance. Nate, what did you think about that?
Well, no, I do understand why, because people kind of feel like bond is like, like the verdict, right? If they're getting out on bond, it means they're free and this. But, I think if we dial it back and say, what's the purpose? The purpose is for you to come back to court, right? So you to show up back to court, and obviously if you're a danger to the community, then we're going to hold you based on those. So I think we have a nonviolent crime, which, I know that's going to upset a lot of people, but it is. You do have this 19-month investigation where the police didn't really feel like he was that much of a threat to make the arrest earlier. And, I do understand the condition that I do have. It's what Natalie said, I think is 100% on point. The condition with the kids, I think, is definitely something, is that should be more stringent, because I don't know if I'd feel comfortable, especially about him acting on this before with his younger sister and those type of things. But I also think on the back end, it just wouldn't be just to keep him in jail for this type of crime on this type of bond. without more. So part of me is saying, yeah, would I be upset if they kept them? No, but I do understand legally why they didn't keep him and why they did apply. Because, at a point, Bernie Madoff got bond and he stole billions and billions of dollars, even though they don't, there wasn't live victims. But here, you don't really have live victims. Like you're saying, it's all electronic. He didn't make the material. He had the material, but it's a harder argument to make to keep him in jail pending trial. But I do understand the public outrage of him being let out. I don't know if that makes sense, but it's kind of like
I get it, but it's hard because even though it's a defendant who's public figure who you don't like, the law doesn't and shouldn't really care. It's like, no, these are the two charges. He was out for 19 months without other incident that has been charged, that he's been arrested for, that he's been, that has come before the court. There's nothing else here. There's a computer crime, and the court made clear this was a close wait for me, but the investigating officer said he's not a threat. So I don't know how you then keep him and override what the investigating officer said. It's also interesting because I think the defense raised some interesting evidentiary issues during the bond hearing. And a bond hearing, the evidentiary standard is basically almost nothing. It's like, show us what you've got. We're not going to make objections on evidence. But it came out that he said early on when the officer showed up to his lot, I need to call my lawyer. And they're like, your phone is going into evidence. Thank you. And it doesn't seem that he was given another opportunity to call his attorney before they interviewed him. So I'm very interested to see what happens because they introduced a pre-Miranda statement. And I'm very interested to see what comes after that interview and if he asked again to be allowed to call. And I understand why they took his cell phone. It's digital evidence. You can go delete stuff. But it didn't seem from the way the defense was asking questions that he was provided another way or opportunity to call his lawyer during that search. And I think that's going to be very interesting to see how that shakes out.
Was the search incident to arrest? In other words,
it was a search warrant. No, it was a search. It was a search warrant.
It was just a search warrant.
Mm-hmm.
So because Miranda, you need what? You need custody.
They interviewed him. So they did stop him and interview him. They told him he was not being detained. They did then Mirandize him anyway. But it's the feds. They're going to Mirandize you anyway. Yeah. I think it'll be interesting to see if he invoked his right to an attorney.
Yeah, but because a non-custodial interview, you don't have to Mirandize. But if he's in custody, then you have the Miranda. That's how it works here. So
yep. No, that's how it works.
Yeah,
that's how that works.
Because I know some places like the merger document in Minnesota. That's why
Minnesota's weird.
Yeah,
they do weird things.
Yeah.
But yeah. If he wasn't in custody, then it would be I think it's a harder argument to sell because especially with the conservative Supreme Court when it comes to Miranda. So yeah. So I think it may be a harder argument, especially if he wasn't in custody and just was interviewed. Then the Miranda. I think the Miranda argument may not be as strong as I thought at first.
What was do you know, like what the circumstances around the pre-Miranda statement? So apparently he made a pre-custodial pre-Miranda statement.
He made a pre-Miranda statement. They said he made a statement saying something like, they asked him, do you know why we're here? And he said, oh, is somebody downloading child pornography? So that is what they say he said. Oh. And then he was in like the back seat of the car with them. And then they conducted the interview. But because it was just a detention hearing, we didn't get all the facets of it. But the way the defense attorney was asking questions, I was like, they think there's an issue here. And I will be very interested to see what happens, because did he say, I want to call my lawyer? Did they provide him another opportunity? Like I need to know how the rest of it went down. Because I'm like, there could be stuff there. And that's, as a defense attorney, it doesn't matter how much you think Josh Duggar sucks. They're going to go after the search, the warrants, and the evidence. That is the job that is their job, to go after all of those things and make sure they were done right.
Yeah.
But you get out though. That's a hell of a statement to leave in there. You got to get that statement out.
Oh, so I just putting on my public defender hat here, putting on my defense attorney hat here.
Yep.
Just so it's clear, when we're talking about Miranda, it's Miranda v. Arizona, which is a landmark Supreme Court case that says that custody plus interrogation means that you have to be warned that you have the right to an attorney, the right to remain silent, that if you can't afford an attorney, one will be provided to you, and that you can stop the interview at any time and request the presence of an attorney to be with you during the interview, right? And that, basically the right to an attorney under the Fifth Amendment right against self-incrimination, because you have the right to remain silent, and the Sixth Amendment right to the representation of counsel when you are charged with a criminal offense. It attaches from the moment that you're taken into custody. But the issue here with Duggar is, was he in custody? And custody is not arrest. That's not what it is, right? Yeah. It's less stringent than you are under arrest, sir. And I'm going to tell you what your rights are.
It's going to be interesting to see if they argue it, because I'm sure they're going to say, we told him he was free to go. We told him he was not in custody. But they also said he was in the back of the car and being interviewed in the back of the car. So I'm like, there are actually quirks here. I don't think it's cut and dry. And it's going to be a very, very interesting. The evidentiary hearings on this, I think, are going to be very interesting.
There was like a famous case that I forget the name of the case, but where the cops where they wanted to interview the person, but they didn't want to give him Miranda, so they knew they were going to arrest him. Like, they had all the evidence, so they were going to arrest him. So instead of arresting him, so they would avoid Miranda, they questioned him, got the statements, and then arrested him like the next day, and was like, oh, well, and the court was like, well, no, because you knew at that time that there was enough to arrest them, then obviously you're trying to get Miranda. But I think because they teach you how to play. Like, there's a course that they give you, interview and interrogation, when you're in law enforcement, and they teach you how to play the game, right? So and generally the game is, if you're going, number one, beat cops who are on the beat, they never give Miranda. That's just what you see on TV, because they tell you don't give anybody Miranda, because God forbid they say yes, then you kill all the detectives who want to question them later, right? So if you arrest somebody in the street, you just arrest them, and since you're not interviewing them, you don't give them Miranda. But when you take them, but then when the detectives get them, then the detectives give them Miranda, because they give it to them under different situations. So here I'm thinking, but I'm not sure how the feds do it, because the feds, they have different protocols, and I'm assuming their Miranda is a little more stringent, because it's it's really at the federal level, sometimes things are a little bit looser, but sometimes, especially when you talk about questioning, you can't lie to federal agents, but you can lie to state police and things of that nature. So it's interesting, because I think the custody piece here, if there was enough to arrest him at the time when they did the search warrant, and I think if you could find real proof that yes, we could have arrested him then I think the custody thing is a real fight. But if I don't think you have that there, then I think this custody issue, because just because you're sitting in the back of a police car, I've seen cases where, we've taken people, brought them in and sat them in, and the person was like, and you tell the people, you're free to leave, you can go whenever you want. And they stay and give you full statements and make full confessions, and then next thing you know, they're saying, well, they didn't give me Miranda. But you were never really in custody. So it's a game that law enforcement likes to play. But I think I do think the custody issue is going to be a really interesting.
It'll be interesting, because with a computer crime, with a cyber crime, until you do the forensics, I don't know how you prove who's at the keyboard. They were collecting the digital evidence because they had the hash files of stuff that was downloaded to that IP, but you don't know who's using that computer until you have everything to corroborate it. So could they arrest him at that point? With the cyber crimes that I've done, if you arrest him at that point, I don't think you can keep him in, because I don't know how you prove he's at the keyboard until you get all the forensic back to circumstantially tie the timelines together to prove he was using the computer, because it wasn't till later they found it was partitioned. The partition was the password. If you think the feds can't find your whole life, they said in the hearing the partition password was what he used for his bank, his social media accounts, and some other stuff. And I'm like, ooh, that's the one I think that's going to be hard for a defense attorney to overcome, because it's like, but it's his password for his Instagram and his bank account. Who's using the partition?
Natalie, because you're still practicing as a defense attorney. I haven't looked at, thank God, it's been like 6 or 7.
Natalie's like, this shit's on the top of my mind daily.
Like, as you guys are talking about, because I'm like, no, there's this. Okay, go ahead.
She's like, let me define the shit for everybody. These are the constitutional rights. This is how it plays. And there are these situations where you can argue both sides of it. Like, did he feel like he was in custody? Did he not? What did they say?
Exactly. Yeah.
Was there nowhere else to sit?
You guys are like, oh, go ahead, Nate. Go ahead.
No,
go.
a very interesting point to this too is the when the cop said, "Let me get your phone," and he was like, "I want to call my attorney." It's interesting because your right to an attorney doesn't really attach until you're formally charged, right? Or so just for him saying, I want to call my attorney with that phone, it's almost meaningless in this sense, unless he was, unless they were formally charging him at that particular point. But it seems like they weren't. So his right to an attorney didn't attach, and then he really is not in custody. So it seems to be almost an uphill battle. And I'm just, but again, I haven't done any of these.
Well, and we don't have all the facts. We have what they presented at the detention hearing, and we have, based on the defense questions, where I think they're going, because you can hear, I'm like, oh, they think
that's weird.
There are some detention issues based on what they're telling the judge. They're like, well, Your Honor, that was a, pre-Miranda statement, and this was this. They think there's some issues there with the evidence, and the judge is like, I know it's not an evidentiary hearing. You've been heard. And the defense attorney, I think, actually was very respectful, just being like, I wonder how much of that was for the court's information about the case and how much of that was for the audience, because there's 75 people and members of the press listening to this going, oh my God, what the state is saying is bad. It's a lot. And the defense attorney is gently reminding, hey, we haven't been through evidentiary hearings yet. We haven't been through process. This is a lower standard of proof. This is just what you say happened. So it was interesting to hear the direction they're going. I think evidence is going to be. What else do you attack in a federal case other than the process?
No, factually, you don't attack anything, because before they charge you, they've got everything that they need. That's why it took them so long to get there. But so there's like two things I want to say about that. I'll take you in like reverse order. The last thing you just said was, why would the defense counsel even like really get into this? Because it's not an evidentiary hearing. Those are good points, as far as like signaling to the media that there's more here than what meets the eye. But also you can work that into your factors for release. So are you a flight risk is one of the factors that the court is looking at. And a sub-factor of that is the strength of the evidence against the defendant. If the strength is weaker, then the defendant has every incentive to want to come to every single court date to fight this out, because they believe in their innocence, because they have this awesome defense, right? I've got this awesome defense. This case has this massive gaping hole in it. He's going to come to court. He's not a flight risk, right? So that's why that's a situation where you do want to get into the facts of the case. And then going further back to what we were talking about, like as defense counsel, the courts don't only look at, or the analysis isn't only, the right to an attorney attaches when you're under arrest. The right to an attorney attaches when you are in custody. And in custody is not just what the officer subjectively thinks. It's also based on the objective situation at the time. So it could be Officer Friendly, who's super duper nice, and he has all of his lights and sirens on. He has the defendant removed from his vehicle. He has the defendant in his own vehicle. The defendant's in handcuffs. He's like, we're just going to go have a friendly conversation back at the station, and you're free to go anytime. You saying I'm free to go while I'm in the back of your police car with a big plastic partition that's bulletproof between the two of us does not make it so, right? In my mind, I'm definitely in custody, and I may not be charged with anything, and I may not be under arrest, but I have the right to an attorney at that point, and you have to tell me that before you start to question me. And another part of that is that if he said unequivocally, I want to speak to my attorney, all questions should have ended at that point. It has to be unequivocal. It has to be clear, right? I want to talk to my attorney. You cannot ask him a single thing until his attorney arrives. It's not, you have to then give him a chance to call his attorney, or you have to come back at him later and say, are you sure that's what you want? When I say I want a lawyer, everything has to stop. Anything that you ask me about after that, yes, even casual, what do you think we're here for? Because that's an interrogatory question. Anything that comes after that gets thrown out. It doesn't come in. So there's a really good argument here that very incriminating statement, super incriminating, would get kicked out if he's in the back of the police car. You're not free to go when you're in the back of a police car.
When the feds are crawling over your place of employment.
You are not.
With the feds.
Where is he free to go to? Where are you going?
What's interesting to me is I want to know, and that's the first thing I thought. Was he saying, "Oh, I'm just getting my phone. I need to call my lawyer," like, "Oh, I'm sly," or was it, "I want to talk to my lawyer"? Because everybody in the chat's like, "Why the fuck?" And I'm like, it matters. Like sitting there saying, "Maybe I think I should talk to a lawyer," is not going to fly. It's, I want to talk to a lawyer, not maybe I should call my lawyer. I think I should have a lawyer. That's not going to stop that conversation. So if he's getting his phone out going, "Oh, I think I maybe should," is different than, "No, I want to talk to my lawyer." And that's what we don't know, because we just heard it touched on in that hearing. But there's some there. And it's interesting because generally federal cases, I can imagine being a federal prosecutor is one of the easier things because your whole case is done. When you're a state level DA, that case walks in as it's happening and you're building the plane as you're flying with the timing, not during COVID, but normally you've got the trial timeline. The feds are like, "No, we're not arresting you till we have your entire life. We will have your whole world before we come and arrest you." And so being a federal public defender, I imagine, would be the worst because you're just going over evidence.
I have. Oh, go ahead.
Oh, I'm sorry.
No, I was saying that I have some friends that are federal public defenders. It's the worst because I live in
Yes.
It's the worst. They barely ever go to trial. By the time the case comes up, it's done. It's done. Yeah.
Those are wheelers and dealers. When you're fed defense, you're dealing. That's all it's about.
That's right.
Which is not, I mean, there's not the thrill of the thing. We would get the cast-offs from like, "Oh, they're not taking this, bring it to the DA's office." And we're like, this is what they're not taking? Because this is better than 90% of the cases that I have. Like, look at all this evidence that y'all brought in already done and stuff. I'm not trying to call a detective on his day off when he may be out of town going, "I need the rest of these reports. Has anybody run ballistics?" They're like, "It's backed up. I don't know when we're going to have actual evidence." I'm like, I have a prelim in like 4 days. So we need evidence. Not with the feds. That's all done. That's all done beforehand. They take it to the grand jury. They walk the grand jury through it and are like, "This is everything they did." And the grand jury is like, "Yep, your whole life. Good enough to me." So it's crazy. I imagine that would be very difficult. And you would get very good at evidentiary motions as a federal public defender.
Yeah. I have a question. Do you think they have surveillance on him? Like, say the wife and kids are out at the park and he's the only one in the house, and that IP, what is it? The internet address. What do you call it again?
The IP address. Yeah,
the IP address. That IP address is like going to those CP websites. Like, because okay, the defense would be that sure, someone is accessing these websites and downloading these images, but it could be anybody in the house. It's not me.
So these were all from his work computer. These were all at the place of employment. So it was all at the place of employment, and it was all accessed when they went to the free space, the unused space. It was all accessed in a partition. So the computer, because I listened to this entire thing. So let's talk about the stuff that the media didn't think was important that we all think is important. So the work computer had his family photo as the desktop, and it was a Linux partition to have one side of the computer Linuxed. The other side of the computer had this Covenant Eyes program that tells on you for everything you do on the internet. So it is a break your porn addiction program, and you have an accountability partner. So everything you do on the internet's downloaded and sent in a report to your accountability partner. The program does not work on a partitioned drive. So everything was found on the partitioned side of the computer, because it's like having two computers in one. It splits your hard drive and they literally cordon it off. And the partition password was his password for his Instagram account, the family Instagram account, and his bank account. And it ended with his birthday. So everything they found was on that partitioned part of the desktop computer in the office. And when they went through the timeline, because they did it with the downloads, they went through his phone and they were like, this is his phone taking pictures of the cars at the car lot. This is when he's on the computer. And they're moments apart. And this is him texting his wife saying that he's still here. And this is when this was accessed and viewed. So they've got the timeline of his phone geotagging him at work, his text messages geotagging him at work and saying he's at work. And then it's happening simultaneously with the stuff on the computer on the partition drive. So that's how they're going to prove that it was him at the keyboard, because that's the hardest part of computer crimes. It's some other dude did it. I wasn't at the keyboard. Other people can access the keyboard.
It's deal time. It's time to make a deal. If they have,
it was partitioned
crazy
to get around the program that would tell on him. Look at this. Look up Covenant Eyes. It is wild, and it's like, break your addiction to porn, break free. We will message your accountability partner, and the two names on the program was him and his wife, because of course they subpoenaed already Covenant Eyes. They know everything about the program. They know everything about the partition. I was sitting there going, oh my. And the court, during the hearing, they put up the summaries of voluminous records, and the court is like, do not reproduce these in any way. Like, do not take detailed notes. These are not to be reproduced. And they're not evidence yet. They're summaries of voluminous records by not the person who did the forensics on them. And I have seen reporting on them being like, this minute, this minute, this minute. I'm like, no, y'all, when the court says don't reproduce it, it needs to come in for the hearing, because the state's trying to show how strong the evidence is and how they know he's behind the computer. But also it hasn't gone through all the evidentiary checks and balances yet. So but that's how they're going to tie him to the computer, geotagging on the phone, geotagging photos, and then this password partition drive. But it's like, yikes. Yeah.
Oh, it's over. They don't need the statement.
they might.
Here's a bold prediction: the judge might throw them a bone by throwing out the statement, and like you're like, yay, and then he's like, and you're guilty,
And we're still done because of the time. The timeline is and when we talk about circumstantial evidence and direct evidence, they carry weight. Direct evidence is, I saw you do the thing with my eyes. I see you. It's on, it's here. It's on film. The circumstantial evidence is, the phone says we're here. The phone says we're here. The computer's doing this. There's nobody else there. Here's the surveillance. And it's building the puzzle pieces, which is how cyber crimes work. And I get frustrated when I see people online going, TikTok says James Charles Snapchatted this person, prison. And I'm like, but you need all of the foundational evidence to prove that that's actually true, and to prove that it's him sending it and doing it. And that takes time, and we don't know if that's being done or not. You can't just say, oh, it looks like it's true. What it might look like on TikTok and what the process for criminal justice is different. The evidence has to be not just gotten legally, but admissible in court, and those things go hand in hand. And if you just
authenticated.
You can't just have some dude on TikTok saying, but this is true. That's not how any of this works. So it's very, very interesting to me. And I think the Duggar case will enlighten a lot of people as to how long these types of digital investigations take to put together, and why at the state level court, people are like, why is no one doing anything? I'm like, they're not a Homeland Security special unit with the time and the money to track this stuff down. This takes time and money. This computer went through Homeland Security's forensic team and the DOJ's forensic team. So this went through 2 levels of forensic analysis, and it takes 19 months to do. So
but
anyway,
one thing I think a lot of people don't also realize is that because criminal law is starting to catch up to the digital age. And what I mean by that is that, like, when I started, it was just cyber crimes were like something.
Say it, Nate. Say it. Back in my day.
Yes, I feel bad by saying it, but I kind of grew up in that age with the computer, where the internet kind of like blew up. And I remember starting where we were like, going on the internet and do things. And now it's like, oh, we got actually crimes that are happening on the internet. But one thing I think it's interesting is that people don't really know how easy it is for law enforcement to go back and track you. Like, you don't know how many cases during the end was just like geolocation, right? Where did you take these pictures? Who did you do? And everything is right there. You're like, oh, you were here at the Walmart. You were here, and just walk it all the way down. And it's interesting because, we all love our privacy and think that we all have this privacy. But if you're doing crimes and you have your cell phone, that cell phone is tracking everywhere you go. And a subpoena to Google will let the police know everywhere you went to. So, I hate to say this, but I think people, if you are committing crimes out there, you shouldn't
teach people to be better criminals, Nick.
Or turn off your GPS because you will get caught. It's a matter of time. Please.
I had a murder case that we used substantial cell phone evidence for, and I had a robbery case that we used substantial Facebook evidence for because they were geotagged with the exact amount of money, literally where the robbery happened, 4 minutes after the robbery happened. And it was like this like dollar billsio photo on Facebook. I'm like, gentlemen, we know where the photo was taken. We know when it was taken. We know your phone. We know it's from your IMEI uploaded to your Facebook account that you're logging into from your phone. What is happening here? And I'm sure, Natalie, as a defense attorney, you go back and are like, you were thinking what exactly? Please explain now.
Oh, just like taking pictures of themselves with the guns that they're not allowed to possess because they have the felony convictions and it's in their phone and puts them right in the location where the robbery happened. So many of my cases have GPS tracking, cell phone tracking, data location in it. So many of them have cell phone warrants and a cell phone warrant expert who has extracted the phone and pulled out the GPS tracking location data information. I have 4 or 5 active murder cases right now. Each one of them has cell phone evidence in it. Thanks.
And it's it's not just, it's the cell phone, and then it's also social media, because TikTok tracks where you are, Facebook tracks where you are, and they all tie you back. We've got a few super chats. We have been on for over 2 hours. It doesn't feel like it. I know, Natalie, I know you've got court in the morning. I just appreciate you guys being here. We're going to sweep a few super chats and then shout out where everybody can find you. And you guys are going to go subscribe to Natalie and Nate, and you're going to follow them on, what are your preferred social media platforms as we scroll through some of these, Natalie? Where do you like to hang out on social?
Oh, okay. So on Twitter, I'm at NatLawyerChick. So not the full thing because they won't let me put my whole name in there, which is fine. And on Instagram, I'm Natalie Lawyer Chick YouTube. I do have Natalie Lawyer Chick on Instagram, but that one's for my friends and my family. So the one
you got a Finsta.
YouTube, is Natalie Lawyer Chick YouTube. So pretty easy to follow. Yeah.
Scott said, I'm embarrassed saying this, but feel uncomfortable hiring a younger attorney, including 30, 40-year-olds, because I feel like an older attorney would know more. I disagree with that statement, but I'm going to let my guests disagree with that statement before I do. Natalie, you're already like, no. Go. Look, older attorneys get you lawyer cat. Older attorneys get you lawyer cat. Going, Your Honor, I'm not a cat. I don't help. That's what you get with older attorneys.
I'm not a cat, Your Honor.
I'm not a cat. I'm here live. I don't understand. Some poor assistant trying to turn it off.
Yeah, it was so funny. The risk you can run, first of all, shout out to older attorneys because we need them,
Absolutely.
Wealth of information. They do, have relationships with the judges and the prosecutors that are invaluable, but they're not always keeping up with their CLEs. They are not always up on the newest updates in the law. We just had a massive update in our law, with police disclosure and all types of different things, and marijuana being the basis for a search or not the basis for a search. Is every older attorney up on that? Not necessarily. Younger attorneys are dogged. They have the emotional and mental bandwidth to go in. I mean, I am a 30-something attorney. I compare myself to the 20-something attorneys. Those 20-something attorneys are going ham right now. They are so good. These defense counsel, we'll share a client. They'll have them in district court. I have them in circuit court, right? And they're like, hey, so I've got your client in district court and I just spoke to his social worker and we're doing this and this and that. And I've gotten all this reports and stuff. And I'm like, I've only spoken to this guy once. How have you done all this? And I spoke to his 3rd grade teacher and I got this packet put together for him and we're going to get him set up with housing. And I'm just like, what are you talking about? Can you get me his most updated number? They have all the stamina and all the smoke, and they're super idealistic and they're super invested. And you need that type of balance when it comes to, the representation that you have. So I wouldn't discount a younger attorney because, again, it's the practice of law. Any one of us can crack open a book, right? Any one of us can pull up the statute on Westlaw and read it and things like that. So it's not the access to the information really. It's, you learn skill over time, of course, but there's something to be said for that motivation that those younger attorneys have.
And it's different, I think, depending on the case. If you're doing highly technical patent filings, sure, you want somebody who's done 100 of the things. But age doesn't necessarily equal experience always. And ask, if you're tracking down a DUI or a criminal case, a younger attorney is going to have the same access to information and might have more enthusiasm to track it down versus the attorney that's like, I've done 900 of these cases. Would you like to plead to this or would you like to plead to this? Because this is how I make my money and I'm very tired. Thank you. Goodbye. So there's something to be said depending on the type of law too. Nate, I'm going to call you just Nat. You're Nat, you're Natalie. It's going to all my brain has stopped after 2 hours. Nate, what do you think?
No, you guys have killed it. But I do want to say about newer attorneys. I still remember, like, when you get that first couple of cases and you're like, this is the most important case of my life, and you're digging into it and you're calling everybody. That's what a younger attorney is going to get you. That case is going to be so important to them because that case is going to explain to the rest of their life, the rest of their career. So when you get a younger attorney, you are going to get somebody who's invested in the case, and sometimes to a detriment. But I think it's because I still remember those first conversations we were having with clients for long hours, not billing correctly, and sometimes it's because you just want it's new and you want to get that experience. So and I think what Emily said is it's extremely on point. Is depending on the case, something more technical, obviously you want experience, but a lot of times it's really not that technical. It's really something like you were saying, Natalie. It's something that you can go look up the book, and and usually that younger attorney has an older attorney guiding them through the process too. So it's not like you're losing with the younger attorney, but I would say this: if you want somebody who's going to be invested in your case a little bit more emotionally and probably take it more seriously, then you'd want a younger attorney. But if you want somebody who's going to get the job done and may not have as much time to care for you, then you'd go with an older attorney. So, and
a lot of times, if you're at a big firm and you're paying for the older attorney, you're getting the younger attorney anyway.
Right.
They'll show you in the billing. You should see it in the billing who's actually handling your case, but that work's getting divided up too. So it just depends.
Oh yeah.
Devlin said, in honor of finding out my husband is in remission, congratulations. This is the best chat ever. And Natalie, stay hydrated. They're here for you. They're here for your skin. They're like, get it. This was a good question. And then I'm going to scroll and then we are going to let everybody go. Does Josh need internet to have his GPS ankle monitored? They handle that. He doesn't have access to it. That thing does its own thing. He won't have access to the internet. So they have their own internal workings, but that is a great question on how it works. Natalie, yes.
It's like a cell phone.
It's through the phone. Yeah. It doesn't go through like an actual.
Yeah. And he won't have a phone. So it will probably go through the phone of the person who he is his third party custodian. Right.
Cool. Yeah. That makes sense. Yeah.
Yeah. Because he's allowed, the judge said, you can go to Walmart and get a Cricket phone and you can take it to probation and they can check it to make sure it doesn't have internet access. Yes, everybody, the cats are playing around in the back. And
they're cracking me up. They're having such a good time. They're so cute.
They're 5 months old. The kittens are just, the Ponards are back there messing around, which is, they've learned to push the door open. Mel Comp, this is fantastic. Thank you all so much. I've been subscribed to all three of you. Thank you, Mel. I hope that breaking down the different aspects of criminal law stuff and reality television is helpful, that people feel like it's accessible. So Amanda Page is going to hire Natalie. The thing is, Amanda, you don't want to have to hire Natalie, but if you do, you probably can't hire her anyway because she's a public defender. People are going to be like, we want to hire Natalie for everything. And she's going to be like,
your money's no good here. That's what I tell her. Your money's no good here.
But you can go sub to her and you can super chat her on her channel and your money is good there. Your money's good on YouTube.
Yeah.
Anna Scher said, my kids grew up with the Duggar kids. IBLP, I don't know what that is. Natalie, any thoughts on IBLP? Ruined my children until we got out of it. Is that the church? More goes on than you know. No wonder Josh is like he is. I'm sorry that's your experience, Anna. I'm assuming IBLP is the church.
I think it's the church. Yeah.
So a lot of people asked what's IBLP, but I think that that's the church. But thank you so much for that feedback and just for sharing that with the chat. I'm going to, we've got a few that we missed. No, we got that. We got that. Sorry, chat. I know you guys had a lot of questions. We will do a bigger Q&A stream. We had lots to talk about tonight. We did that one. I just want to make sure I don't miss anybody. Nate, tell everybody where to find you while I'm pulling this up.
Oh, just go into the search bar, Nate the lawyer. Thank God I'm the only one, the only Nate the lawyer that's figured out the name. So yes, if you just Google Nate the lawyer, I am the first thing that comes up. I'm also on Twitter as Nate the lawyer. And my videos are more I do a lot of police breakdowns and a lot of explainer videos. I like to just explain things. So
I love the way you do your explainers because you're like, you're the jury. It's this, these are the facts. This is my experience. And I love that you bring experience to all of the different aspects of it. I really like the way you make people the jury and you let them decide. I love that. I like getting into like, where's the intrigue in here? Where's the interest in the pop culture? And occasionally shading a lawyer. The H3H3 lawsuit, y'all. Y'all. Natalie, have you seen this yet?
No.
Natalie.
Oh, you gotta watch.
They didn't plead a date. There's no date. Yeah. There's no like, this happened on this date. There's actually no fact. Yes, there's no facts in the entire complaint. Not a date.
Your video is the bomb. You don't know how much I laughed at your video. I was like, oh my God, is this really the lawsuit? Oh, you have to watch it.
I missed this video. Okay.
I try not to throw other lawyers under the bus. I really try to say, maybe they're doing it for this. Maybe they're doing it for this. I don't love this. Other people do it differently. Sometimes you've got a client behind you going, do this, go in. Yeah. I try not to roll the bus over people. And I'm sitting there going, you have to have facts.
No fact section.
And a date. No fact section. No fact section. It's just the craziest thing I've ever seen. There's not a date. Not a date. What date did this happen on? Nobody knows.
You will be talking about it when you look at it.
You'll
I'm excited. I'm excited.
It's a $50 million lawsuit pled without a date and without a fact.
Oh.
It's crazy.
Emily's with the 45-line paper, the date. Yes.
Look, that judge had a standing order. I get particular about the rules. Like if the judge has a standing order, you kind of have to play by the court's rules. And 45-line paper hurts my eyes. I've never seen anyone plead on 45-line paper. It's single-spaced paper. And then when you plead, this was in the Toddy Westbrook suit. The defense attorney used 45-line paper, but then double-spaced his lines. So you couldn't go page 4, line 12, because the lines didn't match up because he used 45-line paper. Why? That's what you get when you hire an old attorney. You get 45-line paper that's double-spaced, so the lines don't match up. So you can't even cite back to the line.
Yeah. She's someone a little younger.
Get you that 26-line paper with the nice double space and the lines it's the picky stuff that bothers me. We've been told that IBLP is the homeschool program run by them. Okay.
I've heard of it. I didn't know that the name was IBLP, but I knew they
didn't either.
Program. Okay.
Yep.
Yeah. Okay.
Motion. These three are together every month on a live stream. I'm sure we can work that out until Natalie is in trial until the ends of the earth.
Once trial goes back full time, you guys will just like never see me again.
We're going to miss you. I love you breaking down the videos.
I'm enjoying this so much, but I've got to try some murder cases, unfortunately.
Well, maybe they'll be streamed on, and we can cheer you on like Elle Woods' friends. Like,
it'll be like, didn't Natalie say that you shouldn't do this? Isn't she doing that right now?
It happens sometimes. We will talk about body cam videos. Nate, you have a request for content. They would love your thought on the Amber Heard body cam videos. I don't know what that is about, but that is a request for your channel. I love that you guys are making content requests. Motion to have Nate's emoji be an owl. Is it because he's wise? I like it. I like the Nate gets to choose. The Brody squad, the Brody bunch gets to pick. I'm sure the mods are tires. Thank you both for being here. We've kept you like 2.5 hours of lawyer chat. It's been so much fun to just get to talk shop and hopefully help people understand a little bit more about how things work. We need to talk reality TV way more next time because we didn't even get into all of that.
If you watch this, get it together, girl. It's crazy. What you're doing is crazy.
Yeah. Well, we will have to absolutely do this again. We will talk more law stuff will come up because Judge Middleton is still running court. We've still got this Triller H3 lawsuit that's popping off. James Charles is getting sued for employment law. We've got criminal housewives. We'll have to bring that in and talk about the housewives indictment and be like, if you're a defense attorney, where do you even go with the international money laundering of it all?
Good luck.
The warrant was invalid.
Good luck with that.
So, mods, thank you so much. I'm going to play our outro. You guys chill for a minute, say hi to the mods on the back end. And Law Nerds, thank you for being here. Don't forget to subscribe to everybody. Like the video on your way out. Thank you for being here. I appreciate you for being a Law Nerd, and we will see you in the next one. Good night. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.